It's Tuesday. I'm back. We have a lot to cover. I'm a little tired. Just gonna be honest. Just going to be honest. Today, I am going to be covering and breaking down a few quick bits because a lot happened in the week that I was traveling. The Erika Girardi of it all. We've got a lawsuit that was dropped, but wait, there's more. We've got earrings to deal with. We've got some new earrings to discuss for me too. And then we've got to talk about her business. I've gotten a lot of questions about it. I know that it's been covered by all of the commentary channels already. So we're going to do the legal side of that. And then we're going to get into this new lawsuit between Dave Portnoy and Insider or Business Insiders. So I'm going to do that one at the end. The subject matter can be a bit triggering, and I get that. So we're just going to cover it at the end. For the replay crew, absolutely love you. There will be timestamps down below after the stream so that you can jump to the topics that you're looking for. But first, I just want to say hello, welcome back. We've got so much to discuss. We've got some fun quick bits before we get into heavier topics. It has been, we got some new piercings while we were in Vegas. This one's new. This one's a fixer. You look, the 90s, I had all the basic bitch 90s stuff going on. And I have two piercings up here, but they never were comfortable. Like they never laid right. And so my amazing friends over at Iron Horse Tattoo, Tony is a fantastic tattoo artist and a great piercer, like a great piercer, and fixed the angle of this hole. And I'm like, yay. So I'm so happy. Like I'm so happy. I'm so happy. I have missed you guys being live. I dropped new videos last week. We dropped a clip down version of the Armorer lawsuit from Rust. The Armorer lawsuit from Rust has so much in it. Like it's the lawsuit where you're just like, wait, what? Wait, what? Wait, what? And so I broke that out of a live stream because it was at the end of like a 3-hour live stream and clipped it down so it was more succinct. So if you just want that lawsuit, it's there. And then I did a collaboration with my friend Aphrodite, who is a tarot card reader. I know tarot is not for everyone. That is okay. For me, it's another way to have a conversation around the lawsuit that we were already talking about. And there's a part 1 on his channel and a part 2 on our channel talking about really all of what I'm seeing in the lawsuits and then asking him what he's seeing. So that was really fun. It's a tough subject matter, but for me, I'm like, look, we know what happened to Helena Hutchins. What we don't know is the lawsuits, what's in these lawsuits, what's going on in the lawsuits, and that kind of stuff, because we all know what happened. Like there's no question about how Helena Hutchins was killed. So it is what it is. And for you guys who are like, I am not a believer in tarot, that's okay. For me, it's another way to have a conversation. And it's another way to have a conversation. And so that's I like having conversations with all different kinds of creators. And we normally have those on their channels. Sometimes we have them on our channels. I talk with all the Bravo content creators who are commentators and Bravo watchers. And for me, I see it as the same. It's having a conversation with another creator about a subject matter that crosses over. So with that, we are going to jump into the quick bits. I saw 2 things slide by that I'm going to address first, and then for all of you that have been on our live streams before, I do questions at the end, and I'll absolutely do questions at the end. So let's see. Carrie Ann asked a great question. I want to know what's happening with Wendy Williams and Wells Fargo. I agree with you, Carrie Ann. I've read the reporting on it, but I still have some questions that for me, just re-reporting on the reporting is not helpful. I need all of the legal documents. Once I have those, I will be breaking it down because the reporting has some very specific language that Wells Fargo is using, almost conservatorship language that she's susceptible to influence in these things. I need more context, and I'm not getting the context I want from the reporting that I'm seeing. That's not to say the reporting's not good. It's that lawyer me wants to see the documents. So I have not pulled those yet, but I will be pulling those and covering it because it is an odd circumstance where a bank freezes an investment account, and it is an investment account, and I want to know what's happening. So yes, I will be looking into what's going on with Wendy Williams. No, I have not had a chance to do that yet, but it is literally on the top. Well, there's two things on the top of my list. That is one of them. The other one is regarding an influencer lawsuit. I saw it slide by. The name of the influencer, I have been tagged on social media. By the way, I love when you guys tag me on social media for like, hey, did you see this? It is the way I see what you're interested in too. And yes, I ask on Patreon, hey, are you guys interested in this story or that story? And I ask in the membership tab over on YouTube as well. But when you guys all tag me in the same things, I'm like, oh, the law nerds would like to know. So with that, the Attorney General in Texas is suing a YouTuber influencer. I do not know anything about that influencer. I know that lots of others have covered that influencer. So for me, it's going to take a little more research than I had time for before today's episode, because I would like to look into the backstory, because it seems that the lawsuit is regarding a pattern of things that have been sold. And there's also somebody who may or may not have rugged a rugged a influencer coin. There's lots going on, and I get it. So those are kind of at the top of my list. Do we have Tati updates? Not today, but we do have Tati updates coming. They keep getting bumped. You guys are like, when? I know they keep getting bumped. Friday is what I'm intending. So Tati on Friday, Duggar on Friday, and we'll see what we find with Wendy Williams. That might get its own episode. So it might get its own episode, and we'll go from there. So Haley asked, did we ever do Tati updates? You didn't miss it. We haven't gotten there yet. There are filings due. And so when I get behind, I'm like, okay, wait, when do we catch up when everything's getting filed? Which is why I waited to do the Duggar motion to dismiss. The government's response is due, so it's easier to just cover those two together. So I totally forgot to say, let me know where you're coming in from, and what you're drinking. I've got my coffee and we're drinking all the things. Mooney Magoo is like, what's rugged? Pulling all the liquidity out from something. I know CoffeeZilla has covered it really well. And I will, if I cover it, it'll be in like the weekly roundup, on the legal side of what that means, not on everything that happened, because others have really, CoffeeZilla dove into that excellently. And I will absolutely dive down into like what the legal ramifications are and what the regulatory agencies say. Regulatory agencies in the US take some time to catch up to things. So yes, the Ice Poseidon case. That is exactly what it is. Thank you. All you are like, wait, are we talking Ice Poseidon? Yes. So, yes, that is what I'm talking about. All right, y'all. It is time to get into today's episode. We're going to start with quick bits. I should roll the intro because I haven't done that yet. Let me know where you're coming in from, what you're drinking, because, I know you guys are in all different parts of the world. So it's all different times of the day. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. All right, you guys, we are going to get to quick bits. I'm not even going to roll the quick bits intro because sometimes it's just like we rolled intros and now we're rolling more intros, but quick bits. How's that? Does that work? We're just going to quick bits. I have a very critical quick bits because, well, no, first, I've been meaning to say this first. I am sending thoughts, prayers, and love to friend of the channel, Heather McDonald. I know a lot of you tagged me in the reporting. I actually reached out to her. She said she is doing better. She fell or passed out during a comedy set and had a fracture. She said she is doing better. I know she updated from the hospital on her Instagram stories. Very, very scary thing. Glad that she reached out and said she was doing better. So I am sending my thoughts and prayers. I really enjoyed being on her podcast, Juicy Scoop. I think she's great. I think she's funny. And it's such, that has to be such a surreal and scary thing. So Leonard, love and hugs are being sent to Heather McDonald from us. And yes, And yes. So there has been lots of reports about it. I know that all of your faves have talked about it. Um, so yes, I love Heather's Juicy Scoop too. So sending lots of love to Heather. It's so scary. It's so scary. So, yep. And I know she kept people updated when she was in the ER. And if you follow her socials, she will absolutely keep you updated. But she messaged, which is a good thing, and was like, feeling better. Thanks for reaching. And I'm much like, Heather, I'm sure tons of people are reaching out. I was very touched that she responded truthfully. I was like, I know you've got a lot going on. I'm worried about you. I hope you're okay. This is critical. And this is, look, after we've sent prayers to Heather, we can get into the most controversial, the most difficult lawsuit I have covered on this channel. It is very hard. This brings out the internal rage. I'm totally kidding. But for quick bits, we need to talk about Caterpillar Cake. We need to talk about Caterpillar Cake. You know why we need to talk about Caterpillar Cake? Because they settled. The Caterpillars are free. Cuthbert and Colin are besties. And it's all good. It's all good in the hood. It's all good. Well, in the UK, truthfully, it's all good with the Caterpillars. It is all good. They did surgery on a cake. Cuthbert the Caterpillar's appearance has been altered to satisfy Marks and Spencer, and it's Colin the Caterpillar. So here we go. Oh my God, there's so many pop-ups. I know. I went to scrape it, but then I didn't want to like deal with the pictures being lost. For those of you that did not follow the Cuthbert and the Colin of it all, the UK had a trademark lawsuit over its ever so popular Caterpillar cakes. These are iconic. And Aldi, being Aldi, has a very similar looking Caterpillar cake to the one from M&S that is, of course, cheaper because that is what Aldi does. But M&S was like, we've had enough. And they sued over the packaging. But on November 5th, 2021, there was a undisclosed settlement that was reached. We didn't hear about it until last week, but an undisclosed settlement was reached. It probably got submitted to the court in November, and then it took a while to get it signed. And it will allow both cakes to exist. Wait, no, that was the two supermarkets reached an undisclosed accord on November 5th, 2021, which will see the German supermarket Aldi make concessions to Colin's intellectual property. In April that year, Marks and Spencer had said that Cuthbert the Caterpillar rides on the coattails of Colin's reputation, and they are free. Cuthbert is free. The best part about this entire lawsuit was that it went against everything I say in lawsuits. Normally, I say if you are in litigation, it is time to just zip it. There are some exceptions to that rule, and some that just don't adhere to that general principle at all, which is fine. So, you know, some don't apply, some don't adhere, and sometimes it doesn't apply. Where it doesn't apply is when you get a social media team that has a legal team behind the company that is full of sass. And that's exactly what happened. Aldi won the hearts and minds with their social media justice for Cuthbert campaign. Hashtag Free Cuthbert was the greatest thing I've ever seen on Twitter. And it brought, look, intellectual property is not a joke. I get it. But also, the social media shade was absolutely everything. It was the best, and I lived for it. So the two cakes do look strikingly similar, but the trademark is over the packaging. So when Cuthbert re-releases, I hope all of you that are in the UK, if you go to Aldi, will you just tag me in your photos of the newly re-released Cuthbert? I imagine Cuthbert is going to have a, new girl who this kind of release party, like Jennifer Aydin's new nose on Real Housewives of New Jersey. Like, it's going to have a release with its fresh face party, I hope. And so I hope for pictures. And when I come to the UK in November, there will be Caterpillar cakes. I will have Caterpillar cakes. You guys are asking if they sell them at the US Aldi's. I have never seen them there. I have asked at the Aldi's near me. They said that they have never seen them there. So They are not re-released yet. Ali C's like, I will go look. They're not re-released yet. I think this is the article that gives us the date. So M&S had accused the German discounter of copying its Colin the Caterpillar cake. Well, let's be honest. It did that. It did that. It did that. The supermarkets confirmed that they reached a settlement, but declined to give details. M&S said it was pleased with the outcome, and Aldi said its Cuthbert the Caterpillar cake was free and looking forward to seeing his fans. Here's the thing. Whatever it cost Aldi to go through this litigation, the amount of, I don't know, public sympathy that they won through their social media campaign in this lawsuit might just be worth it to them. They might have been like, look, we'll concede and we'll change the packaging, we'll change the cake a little bit. But everybody came out of this talking about Cuthbert, not Colin. Though there are some purists who love Colin. I totally get it. M&S said it was pleased with the outcome. Aldi stopped selling the cake in February 2021, and in April last year, M&S accused the supermarket of infringing on its Colin the Caterpillar trademark. The discounter later brought out a limited edition for charity. You guys can go just search Colin and Cuthbert on my channel if you want the breakdown of everything that happened on social media and on this case, because I lived for it. As first reported by The Telegraph, High Court Judge Timothy Bowles allowed the legal claim to be withdrawn on Thursday, and it emerged that the retailers had signed a confidential agreement over the claim in November. So that's why it just hit the media, is because the lawsuit has officially been withdrawn due to settlement. An M&S spokesperson said the objective of the claim was to protect the intellectual property in our Colin the Caterpillar cake, and we are very pleased with the outcome. Aldi Stores UK said in a tweet, getting out early on good behavior, keep an eye out for Cuthy B this spring. So Cuthy B, is this I don't know what happened. Twitter was like, okay, we're happing this. Thank you, Ciara Daly, for tagging me in this story. I saw it when I was traveling. So Cuthy B, will there be a new version of Cuthbert? Hashtag free Cuthbert. So Aldi's Twitter is epic. It's hilarious. We're glad to see a very Olympic-y things, but we're glad to see that Cuthbert has been freed. So yay, Cuthbert. He's free. Cuthbert is free. Cuthbert is free. I repeat, Cuthbert is free. Look, again, I generally say when you're in litigation, it is in your best interest as a human to just. However, there are times when the analysis is worth it. And this was one of those times where I think the analysis for Aldi was to get public opinion on their side and be like, oh, M&S is being so stuck up about intellectual property. And it's like, right, well, you have the right to protect intellectual property, but also. So, that's it. I'm going to be honest. There could never be another Colin. And that's true. Colin is the OG cake. Cuthy B is the new cake. I hope they can all be friends. Colin the Caterpillar was launched by M&S more than 30 years ago. And then it's a history of Colin. Aldi's Cuthbert has performed a skydive to raise money for charity. I mean, Cuthbert seems like the more adventurous of the two Caterpillar cakes. And we love Cuthbert. But Waitrose has a Cecil, Sainsbury has a Wiggles, Tesco has a Curly, and Asda's, I'm going to pronounce that wrong. I always do. I always get corrected. Thank you all. And I still forget. Asda has a Clyde the Caterpillar. So it's not like Aldi's the only Caterpillar cake. There are rife with Caterpillar cakes. Somebody on YouTube did a taste test of all the Caterpillar cakes. You can find it. So I'm ready for Cuthy B. And I'm excited to see, really, truly, the social media campaign that Aldi uses to promote the new Cuthbert or Cuthy B cake when it is released, because I'm here for it. All of it. I'm here for all of it. So I might make my family do a taste test. Also, yes, every time I look at this, the cake looks amazing. And it makes me crave like the Swiss rolls that have like the cake with the chocolate cover, because I believe that that's a bigger version of that. So Call Me Al said, "I hope Aldi makes a Cuthie B jailbird version." I hope so too, because it was funny. The box that said serves 8 to 12 years with the bars were really funny. Even though no one's going to jail over intellectual property, it was still really funny. Look, Aldi, your social media team is goals. They were incredible. They all deserve a raise. If you work with a outside company, they were just the best. They were just the best. Love hearing Emily try to pronounce UK supermarkets. I'm glad I can make everyone laugh in the morning. So yeah, every time I talk about this story, it also makes me want cake, but it's like chocolate covered cake. Like it looks so good. Anyway, Cuthbert is free. They have resolved. I will be very interested when Cuthbert or Cuthie B relaunches to go back and look at the differences between the two. Because the lawsuit was really over the trade dress of the packaging and it was almost exact. So I will be interested to see. Aldi has won some of their cheater brand lawsuits and lost some of them. So it'll be interesting to see what they do next. Look, you can't directly rip things off. There are intellectual property reasons for that. Um, so we need to get on. We need to get on, but I love that. I love that so much. We need to talk about the Jen Shaw of it all for just a second. Can we talk about the Jen Shaw of it all for just a second? This is a quick update. I'm sure there will be more updates soon as we get closer and closer to March. I feel like March is right around the corner, and this trial date for Jen Shaw, like Jen and date and all those words like tried to be one. The trial date for Jen Shaw is coming up quickly, and that is why we have an update. It's like dun dun dun. Another one takes a deal. One of her other co-defendants has taken a plea deal. Now the other co-defendant will not be sentenced until after Jen Shaw's trial. And here's what's happening. Jen Shaw is positioned to be the last defendant standing against the government in this case, which can either be beneficial or hugely detrimental. Here's how I feel it can be hugely detrimental. The government has painted Jen Shaw, Real Housewife of Salt Lake City, out to be the mastermind of the thing, the tip of the spear, if you will, the most culpable, the level AA plus of this fraud scheme that they have alleged against her. She has said that that's not true, denies it all, maintains her innocence. But all of these people who have pled, they are now able to be called as witnesses to testify against her. And if they all testify against her, it is going to be very hard for a jury to be like, oh, well, I guess they're all just ganging up on Jen because they all might not like each other either. It's going to be very interesting. She is going to be in a very difficult spot if Stu, her assistant, I wanted to call him Stu Chains. If Stu, her assistant, and if you watch Real Housewives of Salt Lake City, you know why. But if Stu, her assistant, is Stuart Smith testifying against her, if these other defendants have pled and are testifying against her, A, it's in their best interest to do it because the judge might give them a lighter or a lower sentence because they've cooperated. And B, it's going to make it easier to convict her when you have those involved in the scheme lining out exactly what she was doing, being like, right, we did this part and I take responsibility for my part, but she did that part. Having co-defendants testify against one person sitting on the chair makes it very, very difficult to get an acquittal because it gives the jurors the inside scoop on what happened. And jurors love the inside scoop. I did a couple cases where co-defendants had pled and I brought them in to testify. Generally, they were really annoyed with me bringing them in to testify, but they always said, reluctantly sometimes, this is what I did, this is what they did. Okay. And the jury's well, okay, that's just what it is. So I think with that, Jen Shaw has, I don't know if she's going to reconsider. Maybe this is the equation for her too, that Jen Shaw sees the publicity of trial and looks at the possibility of prison time and is like, look, I'm willing to roll those dice. I'm willing to roll those dice. That's a difficult equation for me, but it might be the right equation for her. And that is her right. She has an absolute right to go to trial. She has a right to be confronted by those who are testifying against her. Ugh, it's just not good. I can't wait to see this trial go down though, and I hope it starts in March. It looks like it might get bumped. I need to keep an eye on what there's other cases that are stacked before it, and I have not gone and looked, but I will to see how those cases are going. The thing with federal court is there is no recordings coming out of court. There is no video in coming out of court. So you have to kind of follow along the court dockets to get that information. So I will pull the other cases and see where they're at in trial. Though I know recent public health concerns in New York have kind of slowed those things down. So, but if Jen Shaw goes to trial, the over under on her testifying is like odds I would bet on. There if she goes to trial, I cannot see her not testifying. Like especially after all of those co-defendants come testify against her, I can't see her not going to court and being like, "But they did this and they did that and they did that and it's not my fault." I can't see her not testify. I think having her co-defendants testify against her would almost bait her into testifying. I don't necessarily think that's a good idea, but she might, and that's her right. I love this mug so much. It holds all the coffee. So, Jen Shaw, is Jen Shaw going to testify? I can see it happening. All right, let's pull up let's see what's the next date they're back in court. They're back in court soon on the Jen Shaw case, but let me pull up. Oh, I don't need to pull up Pacer. The date is irrelevant to all of us. We're like, we know Emily, we don't care. It's fine. It's fine. We're gonna talk about Erika Girardi real quick. So I'm gonna swoop. We're gonna talk about Erika Girardi, and then we are going to move on to the Portnoy lawsuit and then to questions. But there are like three big things we need to talk about with Erika Girardi. And when I asked over on Patreon, to our kind of top tier Patreons, I was like, hey, what do you guys want to talk about most? And they were like, Girardi. So that's what we are talking about. All right. Shall we? We shall. We're gonna swoop and we're gonna get into the Erika Girardi of it all. Should I give a brief road so far? Like we all know this case. Like we've talked about this case so much because there's not just one case, there's so many. Erika Girardi, Real Housewife of Beverly Hills. She is currently filming the next season of Real Housewives of Beverly Hills while this is going down. And I have seen the last girls trip that they were on filming in Aspen or somewhere snowy. um she was wearing the earrings that are the subject to part of what we're talking about today. Those should have been turned over on Friday or Monday. Was Monday the 7th? Is today the 8th? Is it Tuesday? I don't know what day. Look, I was in Vegas for enough days that I don't know what days. I don't know what days. I think yesterday was the last day to turn over the earrings. So this is all going down while they are filming Real Housewives of Beverly Hills. And what we've seen in Real Housewives of Beverly Hills last season is that the girls absolutely asked or the girls, it feels so, the women, the ladies, the wives, the ladies have all asked quite a lot of questions. The Salt Lake City, everybody's like, Meredith, what did Meredith know? What did Meredith do? And I'm like, could you all ask Jen Shaw some questions? Because I don't give a shit what Meredith knew. I want to know what Jen Shaw knew. But the ladies of Beverly Hills were all up asking Erika the questions. So with that, we get well, with that, they are still filming. This is all going down while it's filming. The things that have happened recently are discussion about Erika's business, EJ Global. We'll talk about that last. Discussion of the earrings and whether they have to be turned over. We'll talk about that second. And the lawsuit that was dropped by Edelson PC and what's coming next for that. So with all of that, the Girardi Keith, the law firm, still has a bankruptcy going. Tom Girardi's law firm Tom Girardi personally still has a bankruptcy going. There's still a contempt proceeding going on in Illinois. And those charts were all due. I'm going to pull those up and break those down, not today, on the next show, because we're going to do the Portnoy lawsuit. But those charts were all due of like, we're not going to do it. Also me. Don't do it. Girl, don't do it. Yeah, let's do it. We have time. Let me just pull up Pacer real quick and see if those are publicly accessible, if those were sealed. We're going to look. Don't do it. Also me. Do it now. So there's also this contempt proceeding going on, and the contempt proceeding going on is regarding the Lion Air case, the literal case involving the widows and orphans not getting paid by Tom Girardi. So it is a lot of moving pieces. That is not to say that Erika's not involved in other lawsuits as well, because others have sued her as like a co-debtor to Tom Girardi, alleging that she has received money from Girardi Keese. That's what the bankruptcy trustee is alleging too, that Erika and her company, EJ Global, and others have received money from Tom Girardi. So let's pull up the contempt proceeding real quick and see that contempt proceeding. There's also like Haley Page stuff that happened. We're going to get to that a different day. We're going to get to that a different day. We're going to get to that a different day. I promise. All right. Let us see if those got filed. So much stuff. They were due, but I didn't pull them up while I was traveling. This case, if you could see how much I'm scrolling. Let us see. Sealed document. Yep. And that's what I thought. I thought they were all going to be sealed. Ugh! I'm so curious. Yeah, I thought they might be. But there is a video conference for oral argument regarding the Girardi Keese matter on February 15th, and I will be attending that. Members of the public and the media will be able to call in. I will share that information on social media if you guys want to listen in too. But all the briefing is sealed. I figured that was going to be the case. So I will I will go through document by document, see if any of it is public record. Some of it might not be because it deals with money specifically. Wah, wah. We want to know. We want to see what the charts say. We want to see where the money went. At some point, we'll get some of this information because it'll come up in the bankruptcy. So what's going on with the contempt case is in the Lion Air case, the clients of Girardi Keese and Edelson PC were owed over $2 million. Girardi Keese said they had paid the clients. Edelson PC thought the clients had been paid, then found out the clients hadn't been paid, and then filed a motion for contempt proceedings against Girardi Keese and the other attorneys in Girardi Keese. And this has been going back and forth and back and forth. Judge Durkin in Illinois is like, the fuck with all of this. He was the first one to freeze assets. He was the first one who was like, where's the money? I don't know why this is a where's the money? Where's the money? Where'd it go? Why aren't you just paying it? And literally saying to Girardi Keese, to Tom Girardi on the court call and his attorney, why can't you just pay it? Like, you're supposed to be super rich, bro. Where's the $2 million? And that's the first time his attorney said, yeah, we're not going to be able to do that. And that kind of tipped the last domino to the involuntary bankruptcy and the things that we're getting into now. So that is still a very big deal going on. Edelson PC kind of tipped the media interest, I think, in this case, because A, of the way they wrote their lawsuit, and B, of the things alleged in that lawsuit, alleging the divorce was a sham, alleging that Erika's companies had gotten like $20 million from Tom Girardi. All of those allegations are from the Edelson PC lawsuit. And that's actually a really good segue to just talk about the fact that the Edelson PC lawsuit in Illinois that was filed against Erika, her companies, Tom Girardi, Girardi Keese, other lawyers from Girardi Keese, has been dismissed without prejudice as to Erika only. So let me just pull up that document. And the reason I say without prejudice is because they can refile it. And that is what they intend to do based on statements made on social media and in the media by Jay Edelson, the founder of Edelson PC, saying that they are going to refile it in California, which does not surprise me. Then they don't have to fight over jurisdiction, which was always going to be a question in that case because let's see where the Edelson PC. There are so many cases in the Girardi case that when I don't pull them up properly, it gets all muddled together. And now I have to find where the Edelson PC lawsuit is. Because I think I downloaded. I don't know. This all happened while I was traveling. I might not have downloaded it. I'm just going to pull up the Lion Air case. No, this is the Edelson PC case. Let's see. Where is it? Where is the last filing? No, I don't think I grabbed it. That's all right. It was Tom Girardi et al. I'll just pull up the original complaint and I'll show you everybody who was served on this. So this is the original Edelson PC complaint filed in December of 2021 was the original. This, I think, is the amended. Is this the first? No, this is the motion. But this is the Edelson PC case, not the original complaint. Tom Girardi, Girardi Keys, Erika Girardi, aka Erika Jane, EJ Global LLC, Girardi Financial Inc., David Lira, Keith Griffin, who are other attorneys from the firm, Johnston Hutchins and Lira, which is David Lira's law firm. Robert Finnerty is already out of the case, I believe. Axe Law Firm is already out of this case. Cal Attorney Lending is already out, and I believe Stillwell Madsen is already out. So this has really narrowed down this case. But all of the lawyers involved would have jurisdiction in Illinois because they appeared on the Lion Air case that this is all born out of. Erika Girardi and EJ Global didn't appear on the Lion Air case. So to prove that Erika can be sued by Edelson PC in Illinois on a case that she's not a lawyer on, that she didn't work on, that she didn't do anything with, would be a lot of a fight. And Erika clearly isn't going to concede anything in these fights. We've seen that in the way that she's been defending herself in the bankruptcy parts of this case too. It's not like, no, I'm not going to just say you have jurisdiction over me in Illinois. You don't. I wasn't working on this case. I'm not a lawyer involved in the firm. You can't make me. Like, you have no authority over me. And so instead of Edelson PC and Erika Girardi fighting it out in Illinois, they agreed to dismiss the case and fight it out in another jurisdiction, like California. And those same causes of action can be brought in California. What Jay Edelson said on social media is that there is more information that their firm has, based not just on the show, but other investigation that's been done, things that are being done in the bankruptcy. So I imagine that the new lawsuit will have quite a lot of information in it. And once that's filed, we will be covering it. That might be an emergency ride. Like, if Jay Edelson doesn't say, hey, we'll file this on a Friday afternoon before Friday Night Live, we might do an extra ride for that filing. But I do go live on Tuesdays and Fridays for all lawyers who care to know. If you file on like a Monday, we'll get to it Tuesday. If you file on a Wednesday, it might have to wait till Friday. If you want it on Friday's show, early in the day on Friday. Teasing a little bit. So that's what's going on with that case being dismissed. She has been dismissed from it. It's dismissed without prejudice, meaning it can be refiled, and it will be refiled in California. Jurisdiction. Y'all, all of you are now like, hey, what's the first thing we need to look at? Jurisdiction. It's the first thing we need to look at in all of these suits. Is there jurisdiction or not? Let's talk about the earrings. Let me pull up those files that are in a different subgroup of files. I need that. There's just no good way to organize it because there are so many cases. Let's talk about the earrings. The earrings are part of the bankruptcy case. Emily, did you pull up a picture of the earrings? No. Damn it. Pull up the earrings, because it's the first thing everybody says is, I want to see the earrings. And I'm like, oh, that's fair. Like, that's completely fair. It's completely fair. Did I put a screenshot in this file? No. Oh, fail. We're professionals here, people. I should have done that. I should have 100% done that. All right, let me pull them up, because we're moving on. We're moving on to earring talk, and then we'll move on to the next stuff. Erika Girardi, an image of these. They're massive. And it's so funny because on social, somebody was asking, like, what happens if they take them, appraise them, and find out they're fake? And I'm like, oh shit. I mean, could it happen? How would you know? Would you know? I mean, would you know if they are or are not like the legit ones? I don't know. Who knows? So let's see. The Daily Mail has the shadiest photos, so we're going with those. These are the earrings. These, we saw them all season. They literally like pulled her ear down. They can't be comfortable to wear. Look how much her ear is pulled under. They just looked saggy and sad. But these are the massive diamond earrings that they are fighting over. And there are, let's see, there's some other, she's worn them quite a lot, and she was just wearing them in Vail, but she wears them all the time. So if you go back and look at the season, you will see quite a lot of different scenes where she is wearing those earrings. They are, this is the one I use for my thumbnail, but they are They are large. They are large. They are large. They are large. They're large earrings. So the large earrings are coming up with regard to, let me close all these tabs because now it's going to slow me down. They are coming up with regard to the bankruptcy. I'm going to try to make this concise. It's getting hard to make this concise. The bankruptcy with regard to the law firm. The bankruptcy trustee in that case, Elisa Miller, has sued Erika Girardi and her companies, and that video is on the channel about that lawsuit. With regard to whether or not Erika received funds from the Girardi Keese law firm that are assets of the law firm that need to be clawed back or disengorged from Erika or her company into the law firm. Because the law firm in its bankruptcy is trying, so the law firm part of the bankruptcy, not the personal part, the law firm part. The law firm part of the bankruptcy is trying to find all of the assets that belong to the law firm and claw them back into the law firm to distribute them to all the creditors. Creditors including legal lenders, including clients, including Erika. She's like, I'm a creditor too. That's a conversation for another day. She's saying anything left over is marital property because it would have gone to Tom, probably because she needs it to go into the marital bankruptcy to pay off those debts that she could be on the hook for later. So the bankruptcy trustee sued her for 25 plus million dollars. I covered that lawsuit. It's in the Girardi playlist. That playlist is getting long. I need to separate it now by different lawsuits? I don't think so. Separate it by all the things. So then there was back and forth within that over the special litigator for the trustee who was then removed, and there's a new special litigator from the trustee. We covered that too. Erika saying, look, with all this tweeting, they can't fairly cover this case. I'm prejudiced because of their behavior, blah, 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 blah. So that's where Ron Richards had come onto the case and then ended up off of the case. He says he left. Others say he was fired. The docket says terminated, but that could just be that he chose to leave or not. So there are differing opinions on what happened there. There is a new special prosecutor still going after Erika for any money, well, Erika and her companies, for any money that she might have from the law firm. They filed a joint stipulation regarding the earrings on February 2nd. Literally everything was happening at once. So let's go over this joint stipulation real quick about the earrings. The bankruptcy trustee filed saying the earrings belong to us. I broke that down in a reel and on TikTok. Hey, the earrings belong to us. We think the earrings were purchased for $750,000 from a check directly from a client trust account. You can't do that. But the earrings now we think are worth like $1.4 million. Give us the earrings. Erika said, hold up, wait a minute. I don't know that you're entitled to the earrings. They were a gift. They're mine. I don't think you get them. And then Erika kind of backed up and said, but we can let you hold them in trust for, hello, Joshua, welcome. We will let you hold them in trust until it's determined whether Erika has to give the earrings over or not, whether the bankruptcy trustee gets to liquidate them. And then if they get them appraised and get to liquidate them, then they go out on the open market and somebody gets to buy Erika Girardi's earrings, just like Ryan Bailey got to buy the matching lingerie set that was in Tom Girardi's desk drawer that Erika said was not purchased for her. So in regard, this is why this looks crazy or different. I shouldn't say crazy. It looks different than the other lawsuits we cover because this is regarding the Girardi Keese bankruptcy. This is a lawsuit initiated within the bankruptcy because the bankruptcy trustee is allowed to initiate litigation to claw back assets under the umbrella of the bankruptcy. So, joint stipulation and order regarding holding disputed property in trust subject to mutual reservation of rights and pending final court order and continuance of hearing to allow for discovery. So this is cooperation while still reserving rights. Again, we don't know what Erika knew. We're gonna have to still wait until we have more to know what Erika knew. We don't know. We don't know. We don't know. We know what Tom has done. We know that Erika has benefited. But what we do know is that Erika is going to absolutely try to fight on every single item of property, saying that some of this property, the bankruptcy court can't force her to give up. And while it feels gross, and I get it, you're like, girl, just give the earrings back. Like, just give the earrings back. Like, wouldn't you just want to give the earrings back? She was wearing them on their cast trip just like last week. So that was after, let's see, hold on. We need dates. We need dates. We need dates. And then, oh, tomorrow I'm on with Up and Adam and Zach. And I will ask them about this because they've got all the photos from social media of her being on the trip. But here's the date I want. She was wearing those on a girls' trip last week filming. But this, with regard to the earring, was filed on January 25th. So the trustee had already made this public on January 25th, but the trustee said in their filing on January 25th that they had already asked Erika's attorney and Erika to turn over these earrings. So Erika knew these earrings were disputed when she chose to wear them on a cast trip. It kind of says where she's at with the whole thing. Like, I know, and maybe I am still going to wear them anyway. That says a lot to me, because what Erika knew before all of this is almost not super relevant to me. It's how she's acting now that we know she knows. Because we know she knows now. And it's interesting saying, okay, I'm still going to wear them anyway. Also making that choice being like, hey, it's well reported in the media that these earrings that I am now wearing out in public are worth over $1 million. That seems scary to me. But I don't wear expensive jewelry, so who knows? So, like, I have a threshold for wearing things on my body, and it's well below, it's well below hundreds of thousands of dollars. All right. So joint stipulation, that's the context of it, that these earrings should be now in the possession of the trustee. I'll pull Pacer and see what we see. Oh, excuse me, nose. Y'all, every time I stream, maybe it's my office. I think it's just me. All right. On July 14th, the trustee commenced the above referenced adversary action against, we sued Girardi and EJ Global LLC and Pretty Mess Inc. On January 25th, the trustee filed. Oh, I didn't have to go look at the date. Emily, keep reading. Keep reading. Keep reading. They just put it right in there for you. Keep reading, girl. It's in there. All right. On January 25th, the trustee filed this adversary action for a motion to turn over personal property, which seeks an order compelling the turnover by Mr. Girardi of certain diamond earrings acquired approximately March 2007. The earrings motion. The earrings motion was like, it was interesting. The earrings motion pissed me off. Here's why. Because Tom Girardi wrote $750,000 directly out of the settlement, wrote it off as cost to the client, and took like over 15 million in fees anyway, or costs and fees anyway. So just just buy it out of your fees and buy it out of the money that's yours. Writing it off as cost reduces what the clients get. Just take it as your fees. It's not costs. Pay it out of fees. So with contingency cases, and I talk about this a lot, so all of you give me 30 seconds. I talk about this a lot, but with contingency cases, the attorney takes the case, the client doesn't pay out of pocket. The attorney fronts the costs for the case. After the case is resolved for whatever amount it's resolved for, the attorneys take their attorney's fees first. So if it resolves for $10 million and their contingency fee was 35%, they take 35% of that 10 million off the top. Emily, are you going to do that math? Nope. So they take their percentage off the top. Then they take their costs. They don't take costs first and then take a percentage of what's left. They take their fees, 33 to 40%. Then their cost, hard cost, experts, experts, court filing fees, all that, accident reconstruction, all that kind of stuff. Fees, costs. Then what's left, if anything, goes back to the clients that they won for. So adding it as cost, that's why costs are so offensive to me. Adding it as cost reduces directly what the person gets. You could have just look, Tom Girardi could have said, I got 15 mil, whatever, in fees, put it into his operating account for his business and written the check directly out of his business. Would that be a proper business expense? I am not a CPA and giving financial advice on the internet. That is up for us. That is up for a CPA to decide. I think it's probably debatable, but at least it's not coming directly out of the client's settlement. And that's why I was so deeply offended by this. And and it was to replace another $750,000 earrings that were stolen during a robbery of their house. But again, I talked about this with Zach and Adam, and I can't stop talking about it. If you had lost 700 plus $1,000, like legitimately a really fucking nice house worth of earrings in a home break-in in 2007, why aren't there cameras in your house? And if there are cameras in your house, why don't they know about the break-in with Tom when her son came to help and flipped a car and somebody needed surgery? Why aren't there cameras? Why aren't there cameras? What? Look, I'm not going conspiracy theory. I'm just saying it's odd to have that many break-ins and not have cameras. I worked in the arson unit at the DA's office as a law clerk. A lot of those arsons had insurance issues. Multiple break-ins would raise some red flags for me, but they said the earrings weren't insured. I've ranted about that enough. I ranted about it in another video. If you want to go watch that video or rant about the earrings motion, please do. But that's why I'm so fluffed by it, because I'm just like, bleh. Don't take it away from your clients. Like, seriously, is 15 million not enough for you? Okay. And the Heathers is adding, this was not the first robbery either. Right. This was not the first, well, technically burglary because it's a break-in at the house. But yes, it's not the first burglary of the home. Why don't you have cameras? Also, if you're on television talking about how expensive it is to be you, wouldn't you think you'd put cameras in your house? So, you think you would make yourself a target. We've seen a lot of the housewives of Beverly Hills get broken in. And you saw what happened to Kim Kardashian in France, flaunting jewelry, talking about where she was on social, and getting legitimately attacked and robbed. It is, with social media, the world can track where you are depending on how you share things. And it doesn't make sense to not have cameras. It just doesn't make sense to me. It's sus. For me, it's sus. It doesn't, like, logic doesn't work that way for me. I'm going to stop ranting. I've said that 4 times, and now I'm actually going to stop. I'm actually going to stop. Breathe. On January 26, 2022, Girardi filed a preliminary opposition to the earrings motion. I love that the special litigator called it the earrings motion. It's just, I'm living because it is, because that's what I titled it too. Arguing that the claims in the earrings motion are time barred, affirming her willingness to deposit the earrings into an escrow subject to mutual reservation of rights and pending a final court order, and requesting a continuance to be able to conduct discovery into the underlying facts prior to the discussion on the earrings motion, which again is fair. That's reserving the rights. Look, I don't like it either, but it's legally, it's fair. Reserving her rights, arguing statute of limitations, and saying, I will let you hold them so the trustee will know that they won't be sold or swapped out or anything like that. I will let you hold them until the court makes a final unappealable order. And that's where we're at now. The trustee has reviewed the preliminary opposition, and after discussions between counsel and subject to the approval of the court, the parties stipulate as follows. And this is their agreement. Stipulation means the attorneys have agreed. The terms of this stipulation are subject to an order of this court approving same. So the court has to sign it. I believe the one I pulled is the signed one. I want to answer that question right now. We're just going to zoom to the, yay! Zoom to the bottom. This is the one that's signed. So the court has ordered it and approved this. Subject to a mutual reservation of all rights, meaning no one is saying they agree with the other. It's not Erika saying you're right, you get the earrings. It's them saying I can assert all my defenses and the trustee can assert all of their claims against the earrings. We agree to disagree, but we agree to put the earrings in a safe place, literally to be held. Mutual reservation of all rights and claims between the parties related to the earrings, and without affecting those rights or claims in any way. To maintain the status quo, Girardi agrees that within 5 days of the entry of this order, that would have been Monday, she will deliver to the trustee the earrings for safekeeping and preservation, and the trustee agrees to hold the earrings in trust pending a final, non-appealable order from this court regarding the rights of the parties to the earrings. So the court has to agree, and it has to be a final order, not an order that can be appealed. So this can take a lot of time. During the time the trustee is in possession and control of the earrings, the trustee may obtain appraisals as to the value of the earrings and will make the earrings available for appraisal within 7 days of any written request made by Ms. Girardi through counsel. So if she wants to appraise the earrings, she can do that too. Except when obtaining or allowing appraisals, the trustees will store the earrings in a safe deposit box within a national banking institution such as East West Bank, Bank of America, or Wells Fargo. So they're going into a bank box. To allow Girardi and the trustee to conduct discovery related to the earrings, the hearing on the earrings motion will be continued for 3 months till May 17th, 2022. Put it in your calendars. This is one I'll call in for too. I want to hear this hearing. Put it on the calendar. I should write it. I should make a note. We're just gonna. Where will I be in May? I'll be getting ready to go to Vegas on May 17th. Back to Vegas because I'm speaking at a conference in Vegas. But that's for another day. All right. Mr. Girardi shall have the right to file a supplemental opposition to the earrings, which must be served at least 14 calendar days prior to the hearing date. The trustee's reply shall be served 7 days prior. That's normal timing. They're going to do discovery. It's completely fair because Erika's saying, look, all of the documents are at the law firm. Like, I don't know. I don't have access to those documents. The parties understand that the bankruptcy trustee for the estate of Tom Girardi, Jason Rund, has asserted an interest to the earrings. Of course he has. So Jason Rund is the trustee for the personal side of the bankruptcy. So the law firm bankruptcy trustee is saying, yo, hi there. I saw you from across the bar. Those are some nice earrings you have. It seems like those were paid for with a check from a client trust account. We'd sure like to get those back because that can be sold for like $1 million or more. And that money could go to pay back the creditors in this bankruptcy. And Jason Rund is like, hey there. Hi. Those were a gift. And if those are a gift, those could be a community property. Those might have been purchased with monies that Tom Girardi was entitled to as client fees. So if those are purchased with money that Tom Girardi would have been paid by the law firm, those are a gift. Those are community property. I'd sure like to sell those and pay off the debtors in the personal bankruptcy. So we're going to get both sides fighting over the earrings, both bankruptcy trustees, and Erika being like, the earrings are mine. Here's the thing. If Erika gets to keep the earrings from the bankruptcy trustee for the law firm, they are likely going to have to turn around and be turned over and sold to deal with the bankruptcy of the personal assets, which I think, my opinion, just my opinion and speculation, I think that's better for her. Why? Because we already know that the personal bankruptcy is not going to be discharged. And Tom Girardi is going to have debts that Erika Girardi is a co-debtor on that are not going to be discharged in bankruptcy, and they can still go after her with that. And if they can still go after her, this million plus whatever that can be sold from the earrings is going to allow those debts that can continue to come after her to be paid off. The law firm bankruptcy will be discharged when it's done. Those debts, whoever doesn't get paid is just going to have to go away. That's going to get discharged unless they find fraud and other stuff and decide not to discharge it. But the law firm is not an entity that's operating anymore, so you can't continue going after the company. You could continue potentially going after Tom Girardi, who's in his 80s in a conservatorship. So there's no there. But on the personal side of the bankruptcy, Erika is his estranged wife, but still his wife. And those are debts accumulated during the marriage. And those are debts she can be responsible for. So they can still go after her for the debts on the personal side of the bankruptcy. So for her, the play is to get those into the personal side of the bankruptcy, not the business side of the bankruptcy. I hope that makes sense. So get them away from the law firm and pay off the debts that she could be sued for after these bankruptcies are done. Hopefully that makes sense about why there's a fight between the two on this. And why the two bankruptcy trustees are like, those come to me. And the other one's like, those come to me. That's why it matters so much. So the court made a stipulation. The parties agree that this stipulation does not affect the Tom Girardi trustees' claims and that the Tom Girardi trustees' rights and claims, as well as the rights of the parties with respect to the Tom Girardi trustee, the other one. And then the court signed this order, turned over within 5 days. Doesn't affect your rights. Supplemental filings. Parties have informed the other bankruptcy trustee. The judge signed it. So that's where we're at with that. Let me see if there's a minute order saying that those have been received. Hello, Ivans, Kardashian, Kyle, and 2 times Dorit, the last 3 under Teddy's hubby security company. So they're all under Teddy's hubby security company and got broken into. That's interesting. Plus, it seems that the fight last week, season 12, Trip and Aspen, started because of the earrings. Ooh, T. I'm not surprised. You know why? Because Garcelle was probably like, what the fuck's up with the earrings, man? What the fuck? What's up with the earrings, man? Just give them back. Right? All right, let's go see if there's a cute little order or a note from the bankruptcy court saying that those were received in real time. And then we will move on to the Portnoy Business Insider lawsuit. And then we will move on to questions. Let me see where. Oh, there are so many Girardi cases in in the backside of Pacer. I have so many cases that I'm tracking that it takes me a minute sometimes to find it. But again, it's just. Oh, Ashley Vincent, I see you talking about my nose getting pierced. Look, I have strongly considered it, but we talked about this on Instagram. It was not going to be a impulse move. I needed to think about it more, and I was also nervous about piercing it while I'm still masking a lot because I didn't want to irritate it. So that was part of my thought. But we may at some point. So let's see. The order granting the stipulation is the last thing I see. So it doesn't look like it's been filed, but also if it's been done, the bankruptcy trustee doesn't need to file and say, yo, nothing's been done. So the bankruptcy trustee could have filed something this morning or yesterday if that hadn't been done. So one can just assume that it's been taken care of. All right, let me close this out and we will move on to our others. Oh, no, we didn't talk about our businesses. Hold on. Emily, back up. You're not done yet. We're going to talk about Erika's businesses. So with that, there was discussion. I don't know how it started. It probably started with Ron Richards, but that's an assumption. There was discussion about Erika's business, EJ Global, being suspended by the Franchise Tax Board in California. That is something that is not, I would love to say it's uncommon, but it's not uncommon at all. It happens if people forget to pay their filing fees. In California, an LLC has an $800 a year filing fee, registration fee that you have to pay. And if you don't pay it, your company can get suspended. And then it's not in good standing until it gets paid. There's bigger problems with her company than that from what I saw. But we also know that Erika Girardi is using the new company, Pretty Mess Inc. And Pretty Mess Inc. was first pointed out by, might have been also by Ron Richards in the filing where the trustee's looking for the $25 million because Erika filed this new company at the end of January 2021. So as this was all going down, it was like Erika and her team filed a new incorporation, Pretty Mess Inc. It seems to cut ties with EJ Global because EJ Global is dealing with multiple lawsuits and dealing with all of that. EJ Global, though, as an LLC is probably going to be pierced, and I will show you why. Because EJ Global didn't do the things it needed to do. Again, this is not uncommon in California, but if you run an LLC, there is shit you have to do, stuff you have to do. So this is EJ Global LLC on the website for California's businesses. This is all public record. This is not like special information. It notes that it is FTB suspended. I don't know when it became FTB suspended. Here's the problem. This was registered in 2008. The statement of information was filed in 2009. But then you are required to file a new statement of information every 2 years or a statement of no change. You have to continue filing to keep your LLC in good standing. So this LLC was likely not in good standing before this because if you look at the dates, there is a long time between 2009 and 1/21/2022 when the next statement of information was filed. So when people are looking at this company, EJ Global, in my opinion, is not going to shield her from liability because what they're going to do is say she never kept it in good standing because she never filed her SIs. So this company could have been SOS suspended before it was FTB suspended. And what that means is SOS suspended. The Secretary of State can suspend it for not filing your SIs in time. FTB suspended means you have not either filed your taxes, or paid your minimum filing fee, your minimum tax fee of $800 a year that has to be paid before you file your taxes. So it seems like one of those three things is going to be the case because we don't know when this suspension was levied and we don't know when her company last filed taxes. What we do know is that the SIs that were required in 2009, so 2011, 2013-ish, 14, 15-ish, 18-ish, 2020 weren't filed. So there are a lot of SIs missing. And now it's been refiled. And this was refiled by her current attorney, Evan C. Borges, who are the attorneys for Erika Girardi. We know that. They filed it with just a business suite address. And she is the sole owner manager and has been the sole owner manager, as we see from, nope. Emily, get to the right one. Oh, we got to go this way. Where did my tab go? I hate it when they don't open a new tab. Look, government websites. Can you please just open in a new tab so I don't lose the page that I was on, please? It's so annoying to me when I lose the page I was on and then I accidentally just closed it. I've annoyed myself. You've lost it for yourself, coach. Because I wanted to show you this. Yes, that was a Gunnar Stall reference. For those of you that know, you know. Let's see. All right, EJ Global right here. So what was I saying? I've now forgotten what I was saying because I meant to go back. If you right click, you can open it in a new tab. I learn things every day. Thank you, Law Nerds. You've taught me to control F myself. We'll learn to right click ourselves eventually. The thing is, I have to command click. I'm a Mac user. All right. So this LLC has been a one manager LLC from the beginning. So that's what I wanted to point out. Anyway, me. So with the business, do I think it's that big of a deal? No, because again, we don't know why it's FTB suspended. There's more information needed before I know if it's a big deal, but I imagine she would have been SOS suspended. For me, the bigger deal is that she never filed a statement of information. So how legitimately was the company operating? And I don't think the company was operating in a way that's going to protect her down the road because she wasn't filing those statements of information. So it will be easy for someone else to come in and say, look, she wasn't operating this as a company that's going to protect her. It wasn't funded. It was just a pass-through entity for tax purposes, which when you get into business strategy is something you can choose to do, but it doesn't shield you from liability in the same way. So all those EJ Global lawsuits are going to just pass right through to her. That's the point that I'm trying to make. And that is why it's a big deal, because it just shows again that EJ Global is not going to provide her corporate protection from these lawsuits, which I'm sure she's already aware of. So that. Lord Croco Squirrel, are you making fun of me for being a diehard Mac user? Yes, I get it. I'm still a diehard Mac fangirl. But my kids are using PC, but my oldest does computer gaming, and that's just not a Mac experience. I do basic bitch gaming on a Nintendo Switch. It is time to move on. Are you all ready? I'm not ready. I'm not ready, and I'm going to tell you why, but I'm going to swoop first. I'm going to swoop and make a whole bunch of statements. I'm going to make statements. I'm going to make disclaimers. We're going to do a trigger warning. We're going to do all the things. All the things need to happen before we talk about this subject. So, deep breath, Emily. We're going to get into it. That is the end of our Girardi discussion. It's time to get into the Dave Portnoy Business Insider lawsuit. At what, an hour and 10 minutes here? Let's do all the disclaimer-y things. Let's swoop and do it. All right. Let's do disclaimer-y things. First of all, as I say, whenever we are talking about polarizing figure on the internet, we are not here to speculate about them, to harass them, to name call them, to besmirch their name or character. I know that Dave Portnoy is a polarizing is maybe a mild word, a polarizing individual on the internet. But we are not here to cast judgment. We are here to talk about the lawsuit. Okay. We are not here to name call. We are not here to cast besmirchings. You guys know that. That's all the fuckery. We're not doing that fuckery. You guys are law nerds. We're here to talk about this lawsuit. That said, this lawsuit is also about very sensitive subject matter because the defamation is underlying conversation and claims of sexual assault, consent, the hard R word, and all of the things. This lawsuit details some of those things, and it can be very triggering. So if you are somebody who is not here for discussions about SA and or whether sex is consensual or not consensual, or whether it was consensual and then got too aggressive to still be consensual, it is okay to peace out now. I love you. I will timestamp the questions. It is okay to say, yeah, this isn't for me today. So we are here to talk about a litigation, a new lawsuit between Dave Portnoy, the founder of Barstool Sports and controversial internet figure, podcast host, and Insider or Business Insider, who reported, there's 3 real articles that come up in this that are kind of the crux of the thing. And Dave Portnoy is saying that those articles were defamatory, cast him in a false light. And those articles are around the stories of various women who said that their adult encounters with Dave Portnoy were not what they expected. And we will get into that. So thank you very much for your kindness and consideration as we go through this lawsuit. And as I've said, we are not going to talk about, Dave Portnoy in any kind of a way other than talking about this lawsuit. We're also not going to talk about the women who spoke to Insider in any kind of a way. People are allowed to share their stories. People are allowed to tell their truth. The thing is, it has to be true. And Dave Portnoy is saying that the way it was presented is not true. So we're not going to cast aspersions on those who spoke to Business Insider under anonymity as well. So with that, triggering adult subject matter, I will try to, which I hate having to do because it's like we should just be able to talk about the things because this is a lawsuit. I will try to dampen down the language just because I think it's important to talk about this lawsuit, and I don't want YouTube to completely throttle it because I said the words. But I also feel stupid, mostly because I was a prosecutor for so long, having to really couch words. When we're talking about sexual assault, we should be able to say sexual assault. When we're talking about allegations, we need to be able to talk about the allegations are of what. But I will try to tamper down that language because, again, the reason I want to cover this lawsuit, and I have seen the Barstool Sports community just go after people in a vicious way, which also is something that I took under advisement when deciding to talk about this lawsuit, because I was like, well, lawsuits are important to talk about. Here's why I wanted to talk about this lawsuit. It's not really because of Dave Portnoy. It's because it's a defamation suit, because we are seeing more of these. And there are others that I have been sitting on that I have not talked about, but there are lawsuits against the New York Times. There are lawsuits against reporters like Taylor Lorenz at the New York Times with regard to these types of articles. Dave Portnoy is alleging that this was a hit piece done to damage his reputation and his business. I think there's a real question here if Barstool Sports is a competitor of Business Insider. And if this is one media outlet damaging a competitor media outlet while damage or through damaging their CEO. Is that what's happening here? Is it not? Where are the boundaries um, of what can be reported and said? And I think that really lines up with also what we're talking about in the H3 lawsuit between H3 and Ryan Kavanaugh, because Ryan Kavanaugh is saying, hey, H3 said these things about me, essentially broadcast and published these defamatory statements, and it damaged me and my reputation. And this lines up with that. So I think it's very interesting to talk about. And Dave Portnoy, though he is a polarizing figure, he says dickhead stuff all the time. It's just not for me. You're allowed to be a dick. You can say offensive things on the internet. You can't defame people, and that's the boundary. And it's hard to say where are the boundaries of what can be said on the internet. And that's why I think this lawsuit matters, so we can talk about where the boundaries are of what can be reported, what is reporting in the time of the internet, and that. So as we do that, somebody said that Erika, that's accurate. Yes, there is a new, thank you, Nick. There is a new CEO of Barstool Sports. Dave Portnoy is their founder and I don't leader, most public figure, public face of the company, and former CEO. I guess that's fair. So thank you for bringing that up. So, and apparently also has purple hair at the moment. I don't know what that's about, but I don't know. There's apparently purple hair. So, with all of those disclaimers, and I hate making disclaimers, but I also want to talk about why we're talking about it and why this lawsuit matters. So, apologies. Look, I am not deeply familiar with Barstool Sports. Thank you, chat. This is why I love talking about these things on live stream, because the chat has a deeper knowledge than I do of this company. It's not for me. It's in that. Mostly because sports ball. You all know that I rather watch coverage of the Real Housewives than sports. So it's just not a fit. But again, you're allowed to be a polarizing figure on the internet. You're allowed to say mean words. What you can't do is defame people. So with that, we're going to get into it. So I've given all the disclaimers and the warning words. And if the chat gets saucy, don't you worry. I will just throw it over to members only chat. No, we won't. The law nerds know. The law nerds know. That's a lot of exposition. Emily, that was a lot of exposition. It was. Yes, it was. After this, I need to mods, will you just make a note in our channel to remind me? I'm going to post I'm going to post the links for the insider articles that are at subject here, so that if you want to read the insider articles, you can read the insider articles for yourself, and you can go through this lawsuit. Dave Portnoy posted this lawsuit on his Twitter. If you want to go through the lawsuit and go through the articles, you are welcome to go through them and be like, what do I think? Here's what's important to note about this lawsuit. Here, let me just pull it up real quick, and then I'll come back. I'm going to interrupt myself real shortly. This lawsuit is filed in the district court in Massachusetts. Dave Portnoy, as an individual, not as a company, not with regard to Barstool Sports, as an individual, against Insider Inc., the company, Henry Blodgett, I'm not going to pronounce names well, Nicholas Carson, Julia Black, and Melkorka Lesia. I apologize that I cannot pronounce names, but we know this about me. So with that being filed in Massachusetts, there are some things we need to talk about. This lawsuit was just filed February 7th, yesterday. Massachusetts as a venue is something we're going to talk about, because we have to talk about jurisdiction, and we'll get there as we get there in this. And I love it. But with that, Massachusetts because you guys are thinking defamation. What's the first thing you're thinking? Is Insider going to file a anti-SLAPP motion? So we need to talk about that first because it's going to come up in questions. This is a defamation lawsuit. In a lot of defamation lawsuits, you see an anti-SLAPP motion. We talked about it with regard to the H3 lawsuits. The anti-SLAPP motions matter. Massachusetts has a very limited anti-SLAPP statute. For those of you that are like, Emily, slap what? Who? Slap what? Strategic litigation against public participation is a SLAPP suit. That's what it means. A suit that's trying to make somebody shut the fuck up. Like, hey, you can't say that, you can't do that, you can't do this. Anti-SLAPP statutes are statutes that allow for litigation ending motions to be filed at the outset. The first thing you file to say, hey, I have a right to do what I'm doing. They can't prove that they're going to win. Therefore, I win. Go away. Pay my lawyer's fees. Too sad, so bad. No discovery, no moving forward, nada. In Massachusetts, their anti-SLAPP statute is very, very limited, and it only applies to petitioning government. So it only covers public participation in exercising the right to petition government. This is not that case. So there is not going to be an anti-SLAPP motion that you can file as Insider in Massachusetts. That doesn't mean that Insider is not going to file that there's the wrong jurisdiction. They might, but Dave Portnoy lives in Massachusetts. This is a strategic choice to file in Massachusetts and not in New York. But Massachusetts has a narrow SLAPP statute that is only targeted at the right to petition government. That's it. So with regard to defamation, you cannot file an anti-SLAPP statute or an anti-SLAPP motion. You have to go through discovery or file a motion to dismiss. Motions to dismiss are much harder to win. Also to be noted, because this will get into the New York Times versus Sullivan test with regard to actual malice. We're not going to do that today. But when I was looking through some of Massachusetts history with regard to defamation speech, there was a 2007 holding against the Boston Herald, where a $2.1 million verdict was held or upheld against the Boston Herald for the reckless reporting of a judge's demeanor in handling several cases. And the court was highly critical of the reporter and wrote, this is in the court ruling. So this is the backdrop in Massachusetts when you have someone suing reporters or a newspaper. And what the case said in Boston Herald was, quote, the press, however, is not free to publish false information about anyone, even a judge whose sentencing decisions have incurred the wrath of the local district attorney, intending that it will cause the public furor while knowing or in reckless disregard of its falsity. Keep that in mind because this lawsuit is very well written. The attorneys who wrote this is not trillery at all. This lawsuit is very well written. And the lawsuit tries to point out the ways that they are alleging that Insider tried to cause a public furor and try to have reckless disregard of the falsity. So keeping that recent court recent in the law, 2007, keeping that ruling in mind, you've already got courts saying, hey, you can't just say whatever. You can't try to incite the public against people. You can't cause a public kerfuffle or stir against someone while knowing or in reckless disregard of its falsity. And this lawsuit gets to whether or not, and, Portnoy is alleging that there was reckless disregard for the falsity of the statements that were published about him in Business Insider. So that's, I think, part of the backdrop that's important because, again, Portnoy is clearly a public figure. There's no argument that he's a public figure. He's going to have to show actual malice. He might not have to show actual damages because there's defamation per se allegations here. But that knowing or reckless disregard of its falsity is woven throughout this lawsuit. And I think it's done in a really good way. Whether you agree with this lawsuit or not is different. The writing is excellent. It is well written. It will be easy to understand what they're saying. Okay, warning, we're jumping into all the adulty topics. You're all adults. I appreciate you for being adults and having adult conversations on the internet. I'm also going to are we already demonetized? Let me just, Oh, not yet. Wait, wait, wait. Yep. Great. The only reason it matters to me is because it throttles the reach of it throttles the reach. So, it throttles the reach. And Brandon O'Neill in the chat said, um, I will admit I'm extremely biased on this one. Been following this story too long. And again, there's nothing wrong with being biased and having an opinion. You're allowed to have an opinion and be like, I like this side. I empathize for them. I don't like that side. What we have to do is then say, okay, I like this side versus I don't like that side, but let's look at what the lawsuit is. And it's okay. Acknowledging bias is fine. We all have our own biases. We all have things we like versus don't like. And being able to be like, I like this side. I'm more inclined to listen to them is really helpful because then you can see it. And when you can see it, it helps. When people can't see their own bias is when things get difficult. So let us get into this lawsuit. I've given all the warnings and mods. If we need to extend the time to help mod, let me know because I know this can be a triggering one. So just, let me know. All right. I've given all the warnings. Emily, just get into it. Yep, we're just getting into it. This case arises from defendant's greed. Wait, no, that's the wrong lawsuit. Damn it. Those of you that have been here a while know. Those of you that are new here are like, what is she talking about? It's another lawsuit. This case arises from the defendant's knowing publication of 2 false and defamatory exposés into the private life of well-known founder of Barstool Sports, plaintiff Dave Portnoy. So again, I misspoke. On February 3rd, 2022, a representative for I almost said for Business Insider instead of Defendant Insider. A representative for Insider Inc. gave an interview to Variety boasting, quote, if we get sued, we will defend the case vigorously. News organizations regularly get sued. It's the cost of doing business, which I will say that's not false. I mean, that is accurate. News organizations do get sued. It is part of being a news organization. They go on to say, or they go on to allege, again, lawsuits being allegations and shade. If I haven't already said that, lawsuits are allegations and shade. I will say that lawsuits, if you say it in a lawsuit, you cannot be sued for defamation. It is a privileged statement covered by litigation privilege. So lawsuits are allegations. They are not to be taken as fact. They have to be proven in court to be fact. This is one side of the story. But because we already have the Business Insider articles, we know what their side of the story is. Their side of the story is we have sources and they said this. And I will link those after this. Perhaps it is the cost of doing business for Insider, a publication that generates its revenue through clickbait journalism. They say clickbait a lot. Don't turn it into a drinking game. It's not going to go well for you. They say clickbait a lot. Through clickbait journalism and the publication of false and defamatory hit pieces concerning the country's most well-known figures. To Insider, the truth has always played second fiddle to the dollar. And you're sitting there going, wow, this feels like it was written like I could read it and understand it. Yes, it is written so that you can read it and understand it. It is written so that the public can understand Dave Portnoy's side of the story. And they actually talk about it. Wait, I pulled up the wrong one. Hold on. They actually talk about it because some of the stuff I'm not going to go into as much detail in. And so I want to pull up my highlighted version so I remember. Because this was not a first glance. I pre-read it based on the subject matter because I didn't want, I didn't want to go into all of it, and B, I wanted to see what we were doing because it's, excuse me, the topic or the subject matter is too heavy to just kind of jump into and be cheeky about because even though the writing is cheeky and the writing is good, there's definitely shade in this lawsuit. There's clear and concise statements of the law in this lawsuit, but it's also the subject matter is so heavy. All right. Emily, enough exposition. Yes. Enough exposition. Defendants published as fact that Mr. Portnoy had violently hard R sexual assaulted and sexually assaulted 3 unnamed females, an outright fabrication. Defendants perpetrated their hit pieces as a part of a preconceived plan to sensationalize a story in order to drive reader traffic to an internet location where they could be solicited to subscribe to defendants' tabloid-like publication, further demonstrating defendants' malicious intent. Are we already seeing how they're hitting the elements of defamation in this? Like, it's written so that the media can understand it. It's written so that the general public can understand it, but um, it's also weaving in the elements of defamation from the second paragraph. Further demonstrating defendant's malicious intent, each of Insider's stories was published on a date coinciding with Penn National's gaming quarterly earnings announcements. Penn National Gaming owns a 36% stake in Barstool Sports. Defendant's actions were outside any conceivable notion of actual journalism, which again goes to the defamation. Mr. Portnoy seeks to hold defendants accountable for their willful and unlawful defamation and privacy rights violations. Defendants calculated that, quote, canceling Mr. Portnoy would be lucrative business for Insider. Insider and its staff were willing to cash in on their stories while knowingly disregarding the truth. In publishing the false and defamatory stories aimed at destroying Mr. Portnoy's reputation, again going directly to defamation, Insiders sought to cause the downfall of one of Massachusetts' most well-known entrepreneurs and media personalities. Indeed, Mr. Portnoy's life has been nothing short of remarkable. And then they get into what we see in every single lawsuit is a little bit of a resume of who the person is. The plaintiff will always say, I am the plaintiff, this is who I am, and I'm kind of awesome. Every single complaint, because plaintiff's complaints are written in the light most favorable to the plaintiff. That is the way that is done. So it talks about the beginning of Barstool Sports and how Portnoy was a self-published, self-authored newspaper and handed it out on the subway. They then go to say that under Portnoy's leadership, Barstool Sports has become one of the most widely known sports media and pop culture enterprises in the world. And this is where I have questions too about, well, one, they didn't go that direction with, is this Business Insider taking hits at a competitor by taking hits at Dave Portnoy? Like, I don't know if they see it that way, because Barstool Sports does pop culture. So does Business Insider. They are both publications that are on the internet. I don't know. It's interesting to see, or I would love to know, and I don't think we'll ever get to know. This is what I would love to know, is why they didn't go with the intentional or negligent interference in business relationships. If they're alleging that they knew going after Portnoy would hurt Barstool Sports, a competitor, were they trying to intercede in Barstool's business? I'm curious. I'm curious if we'll see that after discovery. I'm curious if we'll get that far, but it's something that's been in the back of my mind. Wouldn't Barstool Sports be a competitor to Business Insider? I would love to know your thoughts on it. So if you're watching now or if you're in the replay, put it down. Do you see them as competing websites? I'm curious, truly. Because of Portnoy's celebrity and notoriety, Insider viewed him as the perfect target for its false, albeit salacious hit pieces into a celebrity's private life. Insider's defamatory scheme was well planned and nearly a year in the making. They go on to say the defamatory stories would serve as a launch for Insider's promotion on a discounted premium subscription to its online publication, which is very interesting. So they go on to say that without a modicum of journalistic integrity, with Insider's chief executive officer, Henry Blodgett, I'm going to get that wrong every single time, at the helm, Insider, its reporters, Julia Black and Makorka Lesia, and their editor, Nicholas Carlson, collectively defendants, engaged in a calculated smear campaign against Mr. Portnoy by publishing and thereafter refusing to retract and or correct 2 false and defamatory stories on its website, at least suggesting, if not blatantly stating, that Mr. Portnoy sexually assaulted 3 women. So, Insider's allegations are patently false and critically are belied by the evidence actually in Insider's possession. So, that is where we get to they're alluding to the reckless disregard. Is there a reckless disregard for the truth? Did Business Insider know that the statements that were made to them were not truth? Et cetera, et cetera. So let us, you all are very helpful with the name pronunciation. Blodgett. I can do that. Thank you, chat, for always coming to the rescue. Over the past 10 months, defendants have engaged in a targeted smear campaign designed to destroy Portnoy's reputation and boost Insider's viewership and subscription revenue, which includes the following. 1, defendants knowingly or repeatedly published two false standalone headlines to lure readers and potential subscribers to their websites, stating, for example, quote, "I was literally screaming in pain. Young women say they met Barstool Sports founder Dave Portnoy for sex, and it turned violent and humiliating." Insider thereby suggested actual criminal wrongdoing on Mr. Portnoy's part without further explanation, a tactic which is known as clickbait journalism, giving rise to the claim here for clickbait defamation. Just defamation's just defamation. I appreciate the why they're saying what they're saying, but clickbait defamation is not an actual cause of action. Just the defamation per se. And I think they're alluding to defamation by implication, saying that this headline, because this is the headline, that the headline leads to an implication that this was not consensual, and that not consensual being a crime. So that's what they're saying. Defendants published directly and via innuendo that Mr. Portnoy had committed the crimes of hard R sexual assault, and surreptitious recording while in possession of text and social media messages showing just the opposite. Defendants pursued a preconceived and biased agenda aimed at damaging Mr. Portnoy to drive online traffic and subscription revenue to Insider. Defendants improperly and knowingly relied on biased sources who demanded anonymity, all while being in the possession of documentary evidence that each source's story was incredible and unreliable. So again, like the case I quoted, it is them laying out their belief that this was a reckless disregard for its falsity. Defendants published highly personal and private information in violation of the Massachusetts privacy statute and Portnoy's common law right of privacy while affording confidentiality and anonymity to the defendant's alleged sources. Mr. Portnoy has never sexually assaulted anyone, and I think part of this is part of the point of this lawsuit, because I don't remember how close in time, but he did do a video response to one of the articles, if not both of the articles, stating that these statements were false, that this was not true. So he had a statement that came out closer in time to those articles, but this is also another statement of denial in this lawsuit, saying that this is not SA. In fact, this was consensual. That is their side of it. Insider is attempting to cash in on a climate of fear and quote cancel culture permeating the media. I was going to say preeminating, and that was not the right word. Permeating the media, whereby it has become open season for anyone to make any claim, no matter how vile and unsupported, about anyone seemingly without consequence. And we learned from Cardi B's lawsuit that her defamation suit against Tasha K cost her over $1.3 million. So this is why a lot of people do not take on media outlets. And that was not a media outlet. That was taking on a YouTube creator and blogger, not a large media outlet like Insider. When you're taking on a larger media outlet like Insider, you're going to have more litigation. And the reasonable assumption on my part is this will cost millions to litigate, and not everyone is willing to go there. But at some point, you see, like Dave Portnoy saying, no, this has gone too far and this is not true. So they go on to say Mr. Portnoy will not stand idly by while Insider and its Twitter army of executives, editors, and reporters attempt to drive clicks, viewership, and subscription revenue for themselves by recklessly spreading malicious and defamatory lies that Mr. Portnoy engaged in egregious criminal conduct by sexually assaulting 3 women and or recording them without their knowledge or consent. Even after being confronted with the exculpatory evidence that contradicts the maelstrom of false allegations in its stories, rather than admitting to its misconduct and irresponsible journalism, Insider refused to retract, correct, or even update the stories about Portnoy, and is instead maliciously standing by its false and defamatory reporting. Now, months after its initial publication, Insider continues to use Portnoy as bait to attract customers to its subscription service. These were paywalled articles. They may still be paywalled articles. So as I add the links to them, these may still be behind a paywall, but we will talk about them. Insider's conduct here is shameful, but given defendant's track records, it is not surprising. Mr. Portnoy brings this action to clear his name, which I think is part of why this lawsuit's written the way that it's written. To clear his name, to set the record straight, and to recover the substantial damages that defendants have caused him as a result of the irresponsible and defamatory stories they publish about him. They go on to line out the parties. Portnoy is the founder of Barstool Sports. They go through Insider and the members of the Insider team, the reporters and the executives. They are all in New York. Insider's in New York, and all of the reporters and executives are in New York. They are being sued in Massachusetts. Let's just cover jurisdiction. And then before I launch into it, keep reading. The subject matter jurisdiction of this court is properly based on the existence of complete diversity between the parties and the amount in controversy, which exceeds $75,000, which is just the statutory minimum for federal jurisdiction. Fine. This is the real question. Personal jurisdiction over defendants is lawful and proper here where defendants each transact business in Massachusetts generally and or engaged in tortious conduct which caused injury in Massachusetts. Those of you that followed all of the Tati defamation suit in Washington, we have talked a lot about that, about contacts and minimum contacts with the form state. Whether or not Insider will have minimum contacts, we will talk about in a minute. But they hit the legal buzzwords with the engaged in tortious conduct causing injury in Massachusetts. Causing injury in the state might not be enough. The false and defamatory Insider publications were directed to individuals and entities in Massachusetts and caused damage in Massachusetts as well as elsewhere. So it's going to be different than the evaluation we did with a single YouTube channel, one YouTuber talking about it. This is going to be a publication which is going to line up more like International Shoe. All of you are like, International Shoe, or some of you are like, no, we're not back to International Shoe minimum contacts. But if Insider chooses to file a motion to dismiss in part based on jurisdiction, we will do another evaluation of International Shoe. How many subscribers does Insider have in Massachusetts? Do they have employees that live in Massachusetts? Reporters in Massachusetts? What are the contacts that Insider, the company, has in Massachusetts? And then its employees, the reporters, can they also be brought into personal jurisdiction in Massachusetts? They might not. They might just say, we'll do this in Massachusetts. But with the lack of an anti-SLAPP statute, I imagine they would want to pull it into another jurisdiction. Business Insider and everyone else is in New York. So can they pull it back and say, no, come to our state and sue us here in New York? Maybe. What I didn't look at. Well, we'll do that at the end. Okay. We're going to keep going through this lawsuit. Otherwise, I will be streaming for 100 years. So jurisdiction is a big question. Whether they fight it, we will see. Massachusetts is a good form for the plaintiff in this case, because of all the reasons I listed before. Whether defendant will cede to that form or will challenge that form, we will see. And then venue, we're not even going to... Jurisdiction's the first question. Venue, we'll get to later. Because it probably won't come up because they're going to fight jurisdiction first if they choose to fight. If they don't, they're going to cede to it, and then venue is irrelevant, really. Facts. Despite being in possession, and this is going to mimic a lot of what was up above, so some of it I will cruise through quickly. Again, this entire lawsuit is linked on Dave Portnoy's Twitter if you want to read it yourself, and I will put that link in the show descriptions too if you are curious about reading it for yourself, because some of this we've already covered. So they're alleging that Insider published the articles to commercially exploit Portnoy's name and celebrity to boost Insider's subscription revenue service or subscription revenue from their, paywalled articles. That defendants' hit pieces were nearly a year in the making, and then they gave us a timeline of that, alleging that in April 2021, Black, the reporter, sent an email to Portnoy requesting an interview for an upcoming, quote, profile in Business Insider. In her email, Black falsely proclaimed, Again, they allege Black falsely proclaimed. There's no particular angle here. I'd like to cover the full gamut from building a media empire to becoming the face of a meme stock movement. Portnoy declined the interview. Shortly thereafter, Portnoy learned this is going to get harder and harder the more I say his last name. We're going to have to switch to Dave at some point because I don't know why it's challenging, but it is. Shortly thereafter, Portnoy learned that defendants did have a, quote, particular angle for the story. In the weeks and months following the April 2021 email, Portnoy began receiving unsolicited messages from friends, acquaintances, and complete strangers regarding defendants' proposed, quote, profile piece. In those messages, friends and strangers alike informed Portnoy that reporter Black had reached out to them for comment and that Black was working on an article about how Portnoy is a sexual predator and that Black had been in contact with numerous women that Portnoy allegedly had associations with. After a full 8 months of investigating, they put in quotes, Portnoy for defendant's story. On November 1st, 2021, Black again emailed Portnoy requesting that he provide a comment for her story. Black's comment request email contained 38 bullet points of, they say, false and unsubstantiated allegations. And I keep saying they say because it needs to be clear that this is a lawsuit and these are allegations. In her email, Black informed Portnoy that Insider was ready to publish the story and demanded that he respond within 24 hours to the maelstrom of false allegations contained therein. That seems like a bit of a short time span for me, but I'm not a reporter. What do I know? 24 seems 24 hours seems fast for 38 bullet points. Just saying. Insider publishes the false and defamatory hit piece on November 4th, 2021. Defendants published their first defamatory piece on businessinsider.com titled, quote, I was literally screaming in pain. Young women say they met Barstool Sports founder Dave Portnoy for sex and it turned violent and humiliating. They then list the full chain because they talk about the chain trail. They can list whatever words they want here. They're alleging that these are the, quote, sex choking violent stoolies are to optimize the clickbait. So this is still the link to the story. I went to it yesterday and that link is still up. So that is, let's see. It copied wrong. Why did it copy wrong? Oh, the hyperlink's down below. Let's see if we can do that again. Because that did not come up right at all. Nope. Didn't do it this time either. That's weird. It's probably the way I saved this, but I will pull it up. I will pull it up when we get to the end of this. So, a true correct copy of the story is attached as Exhibit A. I didn't download the exhibits with this saved version, but we'll pull it up at the end. Further, the first story was published behind a paywall, requiring readers to sign up for Insider's paid subscription service to access it. This revenue-generating scheme was all part of defendants' nefarious plan, footnote 2. Indeed, the date Insider published the story also happened to coincide with Penn National Gaming's quarterly earnings announcement. Penn National owns 36% stake in Barstool Sports. Defendants knowingly and repeatedly published false standalone headline, including its publication of the URL tags to lure readers and potentially subscribers to their website, thereby suggesting actual crimes and wrongdoing on Portnoy's part without further explanation. Defendants' conduct constitutes a tactic known as clickbait journalism, giving a rise to a claim for clickbait defamation. Adding insult to injuries, the first story contained alleged screenshots and quotations from Portnoy's private text and social media messages in violation of his privacy rights. You see that I made a note that says, well, and the thing is, once you've sent it to somebody else and they've allowed it to be published, it's not a recorded phone call, it's social media messages. The expectation of privacy is a bit different. So I don't know if that part is going to fly, because once you've sent it to a second party, the reasonable expectation of privacy is not quite, there. But that's one of the many claims. The defamatory allegations of sexual assault and forcible hard R sexual assault leveled against Mr. Portnoy are patently absurd and provably false. While the first story is replete with false and defamatory lies about Portnoy, the references to his alleged encounters with two women, referred to therein as Allison and Madison, are particularly egregious and defamation per se. And that's really the heart of whether this is defamation per se. And it's going to get to, because these are the stories of women published by Insider, whether Insider had contradicting information and whether they had contradicting information that in their mind was truly contradictory or not, and whether that gives rise to, ultimately in a jury's mind, to them saying, no, you knew this was false. And that is a difficult thing to parse. Whether this will get to jury, I don't know. It took 3 years for the Cardi B case to get to a jury, but I'm not going to get into all of the details. If you would like all of the details, you can read the entire lawsuit for yourself. We're going to get to parts of what was in the article. So this is the first pseudonym, Allison. They say defendant falsely reported that after a violent and impliedly non-consensual sexual encounter with Portnoy, Allison suffered from severe depression and thoughts of self-harm, which resulted in her seeking treatment at the hospital. Again, they're alleging that it's the connection of those two things based on somebody's story that is the defamation. According to the story, on July 2020, Allison messaged Portnoy notifying him that she was in Nantucket and would, quote, love to see him. Allison met Portnoy at his home where they spent the day by the pool. According to the Business Insider article, Portnoy and Allison then began having violent adult encounters, with the implication that the encounter was not consensual. This is what comes from the article. And again, you're going to have to read the article for yourself to see what you think. But he leaned in and started kissing me, and I didn't know what to do at that point. We went upstairs where he was really aggressive, and I didn't know what to do, and we had sex, and he kicked me out. She said that Portnoy choked her. He kept spitting in my mouth, which was really gross. I was kind of scared. I didn't want to disappoint him. So this again gets to the implication. They're saying that Insider implied that Allison's encounter was not consensual and so impermissibly violent as to constitute a SA. And again, you are allowed to have the type of adult encounters that you want, but both parties need to be on board with what type of adult encounters they are. Consent is required, just an unneeded PSA. But if this goes to a jury trial, it is going to be parsed between truly what the implications were in this argument, and then the women who told their stories anonymously coming into court and saying, this is what I told Insider, and this is what my experience was, because it's based on the truth of the matter. They say that Insider implied that the encounter was not consensual. Defendants went on to state that Allison was so distressed by the events that she could barely talk the next day. Defendants further reported that Allison was hospitalized and due to thoughts of self-harm after the encounter. Defendants published that Allison's mother reported Portnoy to the Nantucket Police Department and falsely suggested that he was under criminal investigation for the SA. Prior to the publication, however, defendants were in possession of the so-called police report. I only take issue with calling it a so-called police report because it is a police report. Just because an investigation doesn't happen doesn't mean the police report's not a police report. A police report's a police report. A so-called report means it wasn't a report, but there was a report. It's me being picky, but also they had the report because they go on to argue that Business Insider had the report showing that there was no investigation. So again, it's not a so-called report, it's an actual report. So they go on to say that prior to publication, defendants were in possession of the report, which highlights the outrageous nature of the allegations that Allison's mother made against Portnoy, namely that he was often seen with younger women, which again, if they are over the age of consent, though it might not be ideal, if it's over the age of consent, it is not illegal to do so. Defendants failed to include these facts from the police report in their first story, and for good reason. The police report does not accuse Portnoy of any criminal conduct whatsoever. Which again, it is not a so-called police report, it is an actual report, it seems. based on their own complaint. The allegations concerning Allison are false and belied by evidence in defendant's possession. So Business Insider had it, and that's why they're saying Business Insider had this, so they knew or were willfully ignorant of the fact that this was false. Further, defendants were we talked about that. Let's see. I've lost my spot because I was talking. Okay, so further, defendants were in possession of the police report filed by the mother, which contained no allegations of sexual assault or any other crime for that matter. Even a cursory review of the police report and Allison's subsequent communications with Portnoy reveal that her story was entirely fabricated, and defendants published it anyway. The day before she visited Portnoy, Allison begged him to let her come to his house. Quote, "I'm on island with all my friends and really want to see you. ... Would do anything. ... Let's hang tonight." End quote. When Mr. Portnoy stated he was unavailable, Allison said, "No, it's your last week," in Nantucket in brackets. So it might have said last week here or whatever, but they clarified that it was Nantucket. The following day, Allison messaged Portnoy again and stated she wanted to have sex with him, saying, "What you doing? Can we bang?" Which again, you're allowed to do. Look, adults are allowed to do adulty things. We are not judging. What you doing today? Free during the day? Can we bang? Yes. Allison and Mr. Portnoy made plans to see each other that day. Just prior to arriving at Mr. Portnoy's house, he texted her, quote, "Don't be nervous. It'll be fun. And if you don't want to do anything, we won't." After spending the day at the pool, Portnoy and Allison had consensual sex in his home. Critically, after Allison was allegedly in the hospital and due to thoughts of self-harm, due to the encounter with Portnoy, she continued to contact him via text messages and Instagram. None of her messages indicated she was in distress. In fact, Allison sought to continue her relationship with Portnoy. On August 1st, 2020, Allison replied to Portnoy's Instagram story in which he announced he was leaving Nantucket to spend the summer in the Hamptons. Allison stated, "Aw, bye. Nantucket is better." After Portnoy responded to her unsolicited message, Allison replied, "I'm in shock that you're still DMing me right now. Like, what's up, Dave Portnoy?" The next day on August 2nd, 2020, Allison messaged Portnoy again. "If you ever want to text me, my number is redacted." So they're saying that they believe Business Insider would have had all of this. Whether Insider addressed all of this with their source before the article is something that may come out. So, well, will likely come out in the case of this lawsuit. And just, I don't know. Allison could say a lot of things to justify her actions, but that it's going to depend on the way it's characterized in those articles, right? Like, hey, this got way out of hand, and so because this got way out of hand, I, you know, I didn't want it to get that out of hand. So, all right. So we don't know what if Business Insider addressed all of those things that they would have presumably had in their possession. They go on to say, as is clear by the evidence in defendant's possession, after Allison was purportedly hospitalized due to Portnoy's alleged conduct, she repeatedly contacted Portnoy in hopes of seeing him again, gave him her phone number, encouraged him to continue their relationship. Defendants were in possession of these messages, and they may have questioned her about it. We do not know yet. Further, despite the police report, despite that, Further, despite the fact, can I just make it my words to make it easier? Despite that the police report did not contain any accusations that Portnoy committed a crime, defendants included references to the police report in the first story, falsely implying that Portnoy was under criminal investigation. Mr. Portnoy was not the only person shocked by the allegations of criminal conduct. Indeed, on November 5th, 2021, in response to the story's allegations concerning the police report, Nantucket police spokesperson, Lieutenant Angus McVicker, which sounds like the most Boston name ever, and I'm living. I went to UMass Amherst for a little bit. I really like Boston. Anyway, Lieutenant Angus McVicker issued a statement to NBC News clarifying that, quote, Portnoy was not under any criminal investigation whatsoever. So if they're allowing that implication to stand, then you get into that realm of defamation per se, where alleging that someone has committed a crime is defamatory per se. These types of crimes would count. these are crimes. They would count. So is leaving that information there. And I think when we get to all of these cases, this might be one of the strongest parts of this case, but we will again need to go to the article, leaving it hanging that he's under investigation by the police for an SA or a hard R, is going to fall under defamation per se, depending on the way that it's written, because they're saying, look, Business Insider would have had the article or had the police report, and they would have known whether that was a closed report, no further investigation. But if they knew that, then is that a willful disregard for the truth? And that might be one of the claims where it's like it is or it isn't. This isn't based on two people's perceptions of an encounter. This is based on a police report. This is this or that. And so this makes it a little bit of an easier defamation per se claim, depending on how the article is written. So then we get into the other pseudonym from the article, Madison. Defendants reported that Madison traveled to visit Portnoy at his home in Nantucket, that Madison messaged him for several weeks, wherein she described to Portnoy her hard R APE fantasy. Defendants went on to describe the entirely fabricated series of events, namely that Portnoy choked and hard R non-consensual SA with Madison. And this is the quote from Insider. It was so rough, I felt like I was being RAPED. It hurt, and I was literally screaming in pain. She recalled crying and shouting, too much, and it hurts. I kept trying to get away, and he was like, stop running away from me, stop running away from me. But again, depending on what Insider says next, that is their source's opinion, because it says, I felt like. So context is going to matter a lot with regard to how the Insider article is written. They say that after the reported incident, defendants reported that Madison slept on the couch for 2 additional nights before flying back home. They say the allegations concerning Madison are provably false. In reality, Portnoy and Madison engaged in consensual adult acts, and defendants were fully aware of that fact. Indeed, prior to publishing the first story, defendants were or should have been in possession of all of Madison's communications with Portnoy, as well as her social media posts. Moreover, it's beyond dispute that as of November 11th, 2021, when Portnoy publicly disclosed these communications while taking steps to conceal his accuser's identity, defendants have been in possession of Allison's social media correspondence and yet continue to retract, correct, or update or any way modify the story. Madison operates a Finsta account, slang for fake Insta. I thought it was Friends Insta. They say fake Insta. Chat and comments, let me know what Finsta means. I'm old. I'm old. I don't know things. So I thought it meant Friends Insta, but they call it fake Insta. Potatoes. I'm just curious. They say it's a term used to describe a secondary Instagram account where the user's identity and often the content of the user's post is unknown to all but a small, carefully chosen group of followers. The posts on Madison's Finsta account unambiguously contradict defendants' false report. All of you are saying fake Insta. Great. Thank you, everyone who knows more than me about the internet. Perfect. All right. Fake Insta. Good. I just thought it meant Friends Insta. Is this just, this might just, see, some of you are saying Friends Insta. This might just be a, potato, tomato. It's the same thing. It's your real friends, but it's your like on the DL account. Either way, Finsta. They say that the posts on her Finsta go against what was reported in the article. On July 19th, 2020, Madison uploaded a picture of her and Portnoy playing Scrabble together. So I don't know if they put the date that this incident did not go as intended or was reported to not go as intended. I don't think they put a date on that. So I don't know if this July 19th post is after. Oh, they're saying it is after. Okay. Keep reading, Emily. Keep reading. On July 19th, Madison uploaded a picture of her and Portnoy playing Scrabble together. The photograph depicts Madison and Portnoy together in Nantucket on the weekend of the alleged SA. In the post, Madison gloated, "Me beating Dave Portnoy in Scrabble." On July 20, 2020, after having consensual adult sex with Mr. Portnoy, Madison then posted a video to her Finsta revealing her true motivations with Mr. Portnoy. In the caption to the video, she wrote, quote, Portnoy was a dick and lame and grumpy. He gets a 2 out of 10 from me. If he ever truly pisses me off, I have lots of content to expose him with. I'm going to stick to athletes. Flying dollar sign emojis. Later, Madison posted a picture of Mr. Portnoy with Donald Trump. In the caption of the photograph, Madison wrote, quote, okay, not my proudest fuck, end quote. Notably, in the days following the first story's publication, Madison sought to take advantage of her newfound notoriety by setting up an OnlyFans account, an online platform whereby the general public can pay Madison for personalized content. That's a good way to describe it. Photos, videos, and live streams via a monthly subscription membership. Despite the fact that defendants had access to Madison's social media and should have been fully aware of the problems with her false and sensationalistic accounts of events, defendants published the defamatory first story anyway. I don't know. There will be some on it if this goes to a jury. And again, we haven't heard a response from Business Insider. This is just the very beginning of this. There will be some that say that, her posting afterwards doesn't necessarily change the way she perceived the adult encounters or what she had consented to versus what he believed was consented to. And that's where a lot of this is going to come down to, as to, consent can change in the thing, but this is it's going to end up being splitting hairs on whether that consent did change to the point where when Business Insider reported these stories, they were accurate stories. So you guys are asking, what is OnlyFans have to do with it? Well, they're trying to paint the women who spoke to Business Insider a certain way. That is what that has to do with it. So, and that is where civil litigation can get really, really ugly. So we will continue on, because saying, okay, not my proudest fuck doesn't mean that her description of the events is not accurately reported by Business Insider, or that she didn't relay those things to Business Insider the way that they reported them. So, continuing on. On November 11th, after taking steps to protect the anonymity of two women who purportedly accused Portnoy of sexual assault, Portnoy published and redacted versions of Madison's Finsta post to all of his social media accounts. Despite having access to this information, defendants failed and refused to retract, correct, update, or in any way modify their defamatory first story. Critically, Portnoy provided defendants with the true facts and documentation concerning both women, including that Portnoy's various press conferences, which Insider admits that it viewed, but Insider ignored the information because of their perceived agenda to harm Mr. Portnoy's reputation. In particular, Insider was made aware that critical text messages were available to them, but Insider did not demand them. Where Insider did include information from Mr. Portnoy, Insider made affirmative effort in its presentation to minimize its import. Readers of Insider's first story were misled into believing something that defendants knew prior to publication was plainly false. The false statements concerning Allison and Madison cast Portnoy in a negative and defamatory light to all readers and have had a disastrous effect on Portnoy's personal and professional reputation, which is critical when we're talking about defamation, because defamation is damage to reputation. That is the crux of it. Then they go into the promotional campaign. I believe that the reason they are getting into the promotional campaign is not just to flame Insider in their lawsuit, but also to prove that it was malicious. So how do we say something's malicious? Well, we prove how much they do it. We prove how they're promoting it. So I think that's why we're seeing a breakdown of the way that this was shared. So, as if defendants' nefarious intent was not already apparent through their actions prior to and through the publication of the story. Just minutes after Insider published their first story, Defendant Black tweeted to her thousands of Twitter followers, soliciting more unsubstantiated tips regarding Portnoy's private life. Insider made clear that they intended to double down on their defamatory allegations by planning to publish a follow-up story concerning Portnoy. To ensure that her tweet reached the widest audience possible, Black pinned her tweet to the Twitter profile, ensuring that the message remained at the top of her feed for all to see. Through February 1st, 2022, Black's tweet remained pinned at the top of her Twitter page. I imagine it's probably still pinned to the top of her Twitter page. So this is the story pinned. I don't know when they screenshotted it. It looks like 6 days after the story was published. I don't know. Y'all can go look at Julia Black's Twitter and see if it's there. Seemingly aware that those who live in glass houses should not throw stones, prior to the publication of the first story, Black took steps to protect herself from online scrutiny. Prior to the first story's publication, Black's Twitter profile contained 4,151 tweets. Just prior to publication, however, Black deleted nearly all of her prior tweets, leaving only 132 tweets visible to the public. I think you can read that two ways. I read that two ways. I read that as either Black, because the first article, and I need to reread it and kind of highlight the parts that I have questions about. But the first article also talks about the Barstool Sports fan base and the fact that they do sometime, campaign people who write negative pieces about Dave Portnoy. So it might have been just a brace for knowing that this article was coming out. So we will anyway, I read that both ways. I don't read that as nefarious, but they do, and it's their lawsuit. So if you all see it as nefarious, tell me the things. Tell me how you see it. They say simultaneously, Insider unleashed its Twitter army of executives, editors, reporters, and employees, shamelessly tweeting and retweeting the first story in a transparent attempt to drum up buzz and notably attract new paid subscribers. Well, they put it behind a paywall. So they put it behind a paywall. Indeed, the nefarious hit piece served as a launch for defendants' new promotion on a premium subscription. On the day the first story's publication, Insider circulated a 68% off subscription promotion, encouraging the public to sign up using Insider's libelous hit piece as bait. It'll be interesting to see how a jury will see that. Like, will a jury be like, oh yeah, ick? Or will a jury be like, stuff gets put behind a paywall? I'm not sure. It'll be interesting to see how you guys read that. For example, Insider's senior politics reporter tweeted a screenshot of the promotion along with the message, heads up that Insider is currently offering a huge discount on its annual premium subscription, so you can currently pay just $4 a month to read incredible journalism like Defendants Black investigation into Dave Portnoy. And then a screenshot of that showing that that promotion was used. Concurrently, Insider launched promoted paid advertisements for its subscription service using Portnoy's photograph in conjunction with a new defamatory headline. Dave Portnoy, was it spelled wrong? They put sick in there. I think it's N-O-Y. Interesting. Dave Portnoy, Barstool Sports founder, accused of allegations involving sexual violence and humiliation. So again, this is getting into the realm of, are they alluding to SA through saying sexual violence without saying it? And is that the impression that is left to the reader? And if that's the impression that is left, is that then defamation per se? And is that, malicious purpose by using it to promote a paid access to the service? They say concurrently having been publicly questioned regarding Insider's true motives in publishing the first piece as a vehicle to generate new subscribers, defendant Lucia immediately took to Twitter to defend Insider's decision to run a paid promotion. A broken record here, but the reason big, important stories like these are behind a paywall is because people spend months working their asses off and need to make a living. Anyways, subscribe to Insider. The next day on November 5th, defendant Carlson tweeted a story from Business Insider concerning Penn National Gaming, which owns 36% of Barstool Sports. In his tweet, Carlson gloated, quote, Penn National plummets 20% after weak earnings and allegations against Dave Portnoy. And again, that gives context, but allegations as to what? So, context. Perhaps most indicative. Emily, are you tired? Yes. Perhaps most indicative of defendants' malicious intent, in the days following the first story's publication, insider employees began contacting Barstool Sports advertisers. This is this is really curious to me because I've not seen allegations in any of the suits that we've covered of the publication going after advertisers. We've seen that be the fallout from insiders pieces on creators like David Dobrik, that the fallout was either that the audience or the fallout was that the greater internet community was like, what the fuck? How are you supporting this? This is bullshit, whatever. But I've not seen allegations of the media outlet going after advertisers, which is odd to me, but also it makes me wonder. And I need to look at Massachusetts law more, but it makes me wonder why there then isn't that tortious interference with business relationships if there's, well, because Dave Portnoy is suing personally and not business and not Barstool Sports. Barstool Sports isn't suing, and Barstool's the one that has the advertisers, not Dave Portnoy. Maybe I've answered my own question. I love talking it out with y'all. Thanks for being there for me. But that's, I think, why they're alleging it to malice, because Dave Portnoy is suing, not Barstool. But going after Barstool's sponsors is is a new one for me. I'd be interested to see. Well, we'll keep reading. I don't love it. I don't love it. I don't love this allegation. I just don't. I don't. It look, I understand doing the journalism. I understand doing reporting. I understand doing expose pieces. I understand calling out whatever's being called out. But for the outlet itself to go after sponsors doesn't sit right with me. Let me know how you think, or let me know what you think about it. It just, that doesn't sit right with me. So, perhaps most indicative of defendant's malicious intent, which is, again, I've just walked myself through the thoughts of why they're not suing for tortious interference and why they're using it to prove malice. In the days following the first story's publication, insider employees began contacting Barstool Sports advertisers, and I imagine there's email chains that they will have access to prove this, informing the advertisers of the false allegations against Portnoy and inquiring whether those advertisers would continue to advertise with Barstool Sports. For example, on or around November 6, 2021, insider correspondent Patrick Coffey, I need to change my name to Coffee. On November 6, 2021, insider correspondent Patrick Coffey emailed a Barstool Sports advertiser stating, I would like to ask whether leadership was aware of this recent story about Barstool Sports founder, and if so, whether there have been any discussions regarding those partnerships and or ad placements. Defendant's conduct was intended to shame Barstool Sports advertisers for working with Portnoy and his company and encourage them to stop doing business with Portnoy. Or, and this is just, you already know how I personally feel about it. The other side is, or they're asking for comment like, hey, we've reached out to Chipotle. Are you still working with David Dobrik after these allegations? But I can absolutely see both sides of this. Was the public saying, well, are Barstool Sports sponsors still working? So they were looking for comment, or were they looking to bring awareness? I want to know what you think about it. I can see that there's two sides of that, where insider would say, we were asking for comment because there was outrage on Twitter, where you're going to get Dave Portnoy and his side stating, you were bringing this to the advertisers to shame them, which is what they said. So this is a copy of the email. I imagine that this was, well, then received by Barstool Sports, and that's how it's in this complaint. So you guys tell me what you think. We're just gonna read the screenshot and y'all decide how you feel about it. Hello, I have a brief query regarding blank advertising. Since blank has partnered with Barstool Sports in the past, I would like to ask whether leadership was aware of this recent story about the company's founder, and if so, whether there may have been any discussions regarding those partnerships and or ad placements. I want to comment down below. I want to know what you think about that. They go on to say, to a large degree, defendants succeeded. Due to defendants' deliberate interference with Barstool Sports business relationships, Barstool Sports has lost no less than $12 million in advertiser revenue since the publication of the defamatory first story. Is is Barstool going to turn around and sue Insider too? That's a lot of 12 million is a lot of money. And that's where that tortious interference comes in. The direct interference with a business competitor, and can we say their business competitor? Direct interference with Barstool's advertisers. I just wonder if there's more of these emails out there. Um Again, you can write the piece, but then following up is interesting to me. So I just want to see what you all think, because I think a lot of us are going to, there's again, two sides, lawsuit. Continuing on. Thank you, Leonards, for having the chat in the chat about it. Some of you are like, no, it seems like a request for comment. Some of you are like, it's a thinly veiled attack. And some of you are like, it seems like interference. Right? And if you're on a jury, this is why juries deliberate, because a jury would have to sit there with 12 people and go, how do you read this? Do you see it this way or do you see it that way? And have a discussion, which is why jury deliberations can take time. Insider publishes a second false and defamatory hit piece. To make matters worse, on January 18th, 2022, defendants, the reporters, again email Portnoy informing him that Insider was planning to run an additional defamatory story. In that email, the reporters request that Portnoy provide comment for their second story. Insider's comment request email contained an additional 28 bullet points of false and entirely unsubstantiated allegations. In their email, they informed Portnoy that they were ready to publish a second story and demanded he respond within 48 hours. Well, a little bit more than 24 hours this time. In response to the comment request email on January 19th, counsel for Portnoy transmitted a legal letter to Insider. I imagine that letter was a cease and desist, but wait, we'll get to it. Putting Insider on notice that provably false allegations contained in the proposed second story, providing Insider with documentary evidence directly contradicting the malicious allegations contained therein, and demanding that Insider refrain from publishing the second story. Defendants published the second story anyway. Well, we knew that was coming. On February 2nd, 2022, defendants published their second defamatory hit piece on Business Insider. Oh, wait. When I went through this, I didn't realize that was literally like last week. Last week? The end of last week? Okay. 3 more women say Barstool Sports founder Dave Portnoy filmed them without asking during sex. And then with the link, I will link these. And after we pull this up, I will pull up the stories. So these are additional allegations in a second article. Emily, did you just reverse yourself? Yes, hold on. Let me pull up the one because it has the letter in it. And I want to talk about that letter before we move on, because then they published the letter too. They were like, here's this. So let me pull that up. Where's my link? Because when I saved it out of my program from highlighting it, it didn't save it with the hyperlinks, but the original has the hyperlinks in it. Let's see. This again, this lawsuit is going to be lengthy. Like it's going to be lengthy. I should have downloaded the attachments, but I didn't. All right, let's pull up the link because the links are still on the internet at this point. We're going to get more screenshots in a minute. Let me pull up that hyperlink. So this is the second piece. And I have a subscription to Insider. So this is the second piece. 3 more women say Barstool Sports founder Dave Portnoy filmed them without asking during sex. And then they add, this is the part I wanted to pull up. This is from the attorneys. Our firm, this was from January 21st, 2022. Our firm is litigation counsel to Dave Portnoy. We are writing regarding the outrageous false defamatory statements you made about Mr. Portnoy to Julia Black and others in connection. No, this is a different letter. This is a letter to someone else. This is a letter directly to one of the individuals. The day after Portnoy tweeted his lawyer's letter, Bretler wrote directly to Kyla and demanded that she renounce the statement. So this isn't the letter to Business Insider. This is a letter to one of the women saying, we demand that you retract. That's why I pulled the letter up, because I thought it was the letter to Business Insider. Did they include their letter in here? I don't think that they did. It's a very long article, as you can see. And I will link these. Let's see. I don't think they included their letter. They just included the letter to one of the women involved. Okay, we'll get to that in a minute because that comes up in the lawsuit. All right. Let's see. Um, Titled Three More Women Say, okay, we got to that. For search engine optimization and clickbait purposes, the second URL included the words and phrases Portnoy, new women, sexual misconduct, filming, sex, and without permission. And again, as we're talking about the legal side of this, will sexual misconduct be enough to count in the defamation per se? Because again, saying that in the title or the link can count. I mean, the Johnny Depp Sun case was over a headline and what was said in the headline. So things that are said in that can come in as part of the defamation. They are alleging lots of defamatory statements, but it only takes one to win a defamation lawsuit. They say, in short, the story falsely accuses Portnoy of sexual SA and forcible hard RSA. Defendant's narrative of events is preposterous and critically belied by the evidence in defendant's possession. The second story alleges that Kyla first messaged Portnoy on Instagram in the summer of 2017 and then took an Uber to Portnoy's house to visit him. Defendants further allege that Kyla and Portnoy had violent sex and that it was just too much. Kyla alleges that Portnoy filmed her without her permission. However, despite Portnoy's alleged violent and non-consensual conduct, I don't know if that says non-consensual. I think that says it was too much. So it was too much. It can mean a lot of things. And it can start, again, things can start consensual and change. Spoken like a prosecutor. Yes, Emily, spoken like a prosecutor. There are no criminal allegations or criminal investigations, as has been made clear, going on here. It's just me. All right. Let us continue. However, they say despite Portnoy's alleged violent and non-consensual conduct, Kyla was eager to see him again. About 1 month later, Kyla again visited Portnoy at his home in New York. Defendants went on to report that, quote, the sex during her second encounter was far rougher than she had anticipated or would have agreed to had she been asked. Kyla further admitted, yes, it was technically consensual sex, but that was not the sex I consented to. Again, if that's what she told Insider, is that defamatory? That's her opinion. And if Insider doesn't extrapolate beyond that, that's her opinion, unless they are saying she never said that to Insider. Because if Insider has a source, they are reporting what the source said, because that's what the source said. They say that defendants also falsely reported that Portnoy attempted to force Kyla to have anal sex during this encounter and that she had injured a rib from rough sex. At a minimum, the second story implies that the encounter was not consensual and was, so impermissibly violent as to constitute SA. The allegations concerning Kyla are provably false. In reality, Portnoy and Kyla engaged in consensual sex, and defendants were fully aware of that fact. Indeed, in messages that post-date the alleged encounters between Kyla and Portnoy, Kyla repeatedly referred to those past interactions in only positive terms. In March 2019, after describing a really good, albeit scary, aggressive sexual encounter she supposedly had with another male celebrity who, according to Kyla, would pin her down and choke her a little, slap her around a little, and bite her, Kyla teased Mr. Portnoy about his sexual prowess and suggested they get together again. Several months later, in an unsolicited message, Kyla informed Portnoy that he would 100% get laid if he helped her find a home for a certain rescue animal. While the second story claims that it took Kyla months to process what happened to her, 2 years after the alleged non-consensual sexual encounter, Kyla messaged Portnoy, "Miss that dick." It seemed that he messaged her something. We don't have dates, so we don't know how long these are in between. That's what they're saying, that it was 2 years after the encounter that was the text. At no time during her extensive text message exchange with Portnoy did she complain about him being violent, abusive, or recording her without permission. Again, you can read that two ways as to if somebody is saying they've been recorded without permission, would they want to piss off the person that had that recording? Because it can be read that way too. But again, we will see what Insider says. In fact, Kyla joked about how she injured her rib during one of their encounters and boasted to Portnoy that he, quote, still holds her title for most aggressive sex. And again, aggressive sex can be consensual. I'm not here to tell anybody what they want to do with their life. You do you. But they included that exchange in here, which again, they're saying Insider had all of this. So if Insider had all of this, then can they still publish those statements? And is it fair to construe an article saying that it was, or implying that it was non-consensual, if they had all of these messages afterwards implying that while aggressive, it might have been aggressive and consensual? And that's the back and forth in this, and why they're putting this in here to show, look, Insider would have known all of this, and they still chose to say that this was not consensual. However, we'll see what they say. People can regret something and still keep up a banter, but how are you allowed to then report on that? It just has to be with I don't know, with clarity on both sides and explaining, hey, but you continued to engage afterwards. Why? And including that can help with it. So we will see. I think because we are dealing with matters of consent and perhaps withdrawn consent, and the statements from the women are saying, yes, I consented, but this is not what I consented to, which withdrawn consent can happen at any time. This can be very, very, very difficult to go forward at trial. The things that are going to be less difficult for a jury are things like the police report and leaving that hanging, implying that somebody's under investigation for SA. Those are documents. So, again, Portnoy's counsel provided defendants with true facts and documentation concerning Kyla, but Insider ignored the information because of their perceived agenda or preconceived agenda. In particular, Insider was made aware that the critical text messages were available to them, but Insider did not even request copies of them from Portnoy or his attorneys. Where Insider did include information from Portnoy, Insider made an affirmative effort in its presentation to minimize its import. And again, Portnoy listed this on here. Now I've got to answer my own question. We interrupt this regularly scheduled lawsuit to go to Twitter real quick. I imagine that I pulled this from the case filing system. I just wonder if he included the exhibits, because those articles are attached as exhibits. And follow on Twitter, but let's see. Where is there we go. So he attached it on his Twitter, and I'm just wondering, I'm going to pull this up. I'm just wondering if that included wait, where is it? It said you can read it if you want to. Did he put it on the website? Maybe. As I tell you all that he posted it so people can read it, and then I'm like, well, how do we link to it? Let's see. Lawsuit filed. Okay, but where is the rest of it? Is it there? Now I have to file, because of course I didn't flag it when I should have yesterday. Here we go. Barstool's. Okay, so it's on Barstool Sports. I'm wondering if they attached the Insider articles so that you can just go to one place for them. That's what I'm looking for. So, yes. All right. So the exhibits are attached to the one that's on Barstool Sports. If you want to get it from there, you can. And it has the first article. They are long articles. It has the second article so that you guys can look at the lawsuit and look at the articles and decide if you think that the implication was made, if you don't think the implication was made. And what's not attached there is a third article that I will also link in the show notes, and I will link that in the show notes. A third article from one of the editors at Insider saying this is why we published these, and this is why we chose to publish them, because that's in there too. All right, let us continue. Let's see. They're saying that Insider didn't look at the other side. And despite the fact that prior to the second story's publication, defendants were provided with the post-dated communications, and Portnoy was fully aware of the problems with her sensationalistic account of events, defendants' in-house counsel, so Insider's lawyers, promised to be in touch to give Portnoy ample time to comment. Defendants published the second story anyway. So the lawyers talked. At least on, when did he respond to what's the date that he responded with a letter from the lawyers to them? It was at the end of January. So it was like a week later. An email request on January 19th, and then the article was published on February 2nd. So fairly close in time. They say Insider runs its second promotional campaign. Defendant Black again tweeted to her thousands of followers seeking dirt on Portnoy's private life. If you would like to share any information connected to this story, you can reach us securely, and then providing their emails. For me, I'm like, oh, okay. I mean, they are reporters, journalists asking for more information. I don't think that's defamatory. I understand that that is contextual, but okay. Anticipating the backlash from the outlandish allegations. Did I? Oh, no, I didn't. I was like, did I go too far? Are we back to deleting tweets? No. Anticipating backlash from the outlandish allegations contained in the second story, defendant Carlson posted an editor's note on Insider's website titled "Why Insider Published Its Dave Portnoy Articles," and I will link that here too, and we'll go to that. In the article, Carlson further defamed Portnoy, stating that he took, quote, "a sexual encounter that began consensual and turned it violent without first asking his sexual partner for permission." Carlson further describes Portnoy as a, quote, "rich, famous, and powerful person who uses his power in a way that is harmful to other people." Carlson then pinned that article to the top of his Twitter account. An Insider representative gave an interview to Variety in which Insider welcomed a lawsuit and claimed such lawsuits were the cost of doing business. I haven't looked at how many times Barstool Sports has been sued, but publications do get sued. I don't know. I don't read that as them like bragging, yeah, we're doing shit so we get sued. I'm reading that as like, hey, that happens. I mean, maybe that's just me. That's how I read it. But I will also post the why Insider published, and we'll look at that real quick when we get to the end of this lawsuit, because I think it's Insider's side of like why we did this before Insider answers this lawsuit. And the answer will probably be in the form of you don't have jurisdiction here, but we'll see. The effects on Portnoy's reputation have been pervasive and continuing as a result of defendants' defamatory statements. Portnoy has suffered significant and irreparable damage to his reputation and profession, as well as embarrassment and humiliation. Those go to the causes of action directly. To any reasonable reader of the Insider stories, the clear and essential gist and sting of the defendant's overall publications is that Portnoy is a rapist, an abuser of women, and a person who secretly records women having sex without their consent. Yet defendants intentionally ignored and or intentionally buried, terribly pronounced, buried in their stories, actually provided and or readily available and known evidence establishing precisely the contrary. Precisely the contrary. Simply put, defendants slanted material facts in their published stories pursuant to their preconceived agenda to harm Mr. Portnoy. In doing so, defendants ignored, for example, and without limitation, that the sex which took place was fully consensual, as reflected in the text messages of the women themselves, and that the women themselves either enjoyed and or never protested their encounters. I have feelings that I'm keeping to myself. Okay, as reflected in their text messages, and that all recordings were done openly and notoriously with the full knowledge of the women who voiced no objection whatsoever. I think that is, well, I understand that they are characterizing it that way for theirs, but I don't know if that sets the lawsuit aside, saying, but they didn't object. This is not a criminal investigation. We are not going into whether consent was withdrawn for the purposes of any illegal behavior. This is going to truth of the matter for the purposes of defamation. So, mm, count one, defamation, that the overall portrayals that he is a abuser of women and a person who records people without their consent, because those are crimes that would fall into the defamation per se. They go through the different statements that they find and are saying are defamatory. Um, some of these are opinion statements, so some of these are going to be harder to prove. Some of these are implications, and defamation by implication can also be difficult to prove. But it is provable as defamation. You can have defamation by implication in most states where it's you didn't directly say it, but you left enough of the implication that you are implying that this person committed these crimes. So they list out the statements that they find defamatory. I think some of these are opinion, but again, in a defamation suit, it takes one, and I think the thing that will be easiest for them to prove is surrounding the police report. There was a police report. How did they leave that hanging? And did they leave that hanging in a way where it seemed that he was under police investigation for these acts? That is different. So with this, some of these are going to be opinion. And so it depends on how they contextualized it in the article as to whether it's defamation, really through implying something. So those are the statements they're complaining about. They're saying that the stories are defamatory per se because they accuse Portnoy of having committed crimes, including essay and unlawful recording. The invasion of privacy goes to the right to privacy to be let alone and let to be free from public discourse. Again, defendants releasing and publishing Portnoy's highly personal text messages and social media messages amount to an unreasonable, substantial, and serious interference with an invasion of privacy. I don't know on the invasion of privacy if that is going to fly, because I don't think you're going to say when somebody is a public figure with this with the persona that he has, whether that is an unreasonable invasion into privacy. I can understand why they're alleging it. It's interesting to me that they didn't allege intentional infliction of emotional distress after the when the second article was published saying, hey, this is why you're going after this. But yeah, I don't know about the invasion of privacy with regard to the text messages. What I want to look at is what some of the other cases in Massachusetts have decided, because the messages aren't presumably private. You've sent them to somebody, but that doesn't mean they just end up in a publication. But this is a matter of public interest. So is it an unreasonable invasion of privacy in line with the story? I don't know. I have more questions on the invasion of privacy. With the defamation per se, it's going to break down to what are the implications, because a lot of those statements are the people sharing their experience and opinion. So it's how it's construed by Insider. But I did want to pull up the why Insider published, because they also published that statement, I think, with litigation in mind, and I'll tell you why. So let's pull this up on the editor's note. Let's see. And this was published February 2nd, 2022. So this would have been published after the second thing came out. Let's just ads. So editor's note from Nicholas Carlson on Insider's Dave Portnoy articles. In November 2021, Insider published an article in which 3 young women said they met Barstool Sports founder Dave Portnoy for sex that began consensual, but during the course of the encounters turned violent and humiliating in a manner that they would not have agreed to if he'd asked. 2 of the women also said Portnoy filmed their encounters without their consent. In response, Portnoy said he had never done anything that's remotely not consensual. He challenged the credibility of the women in our story. On Wednesday, Insider published a second article in which 3 additional women said Portnoy filmed them during sex without asking first. One of the women said Portnoy broke one of her ribs during the encounter. Through an attorney and on social media, Portnoy acknowledged the rib injury but said that the encounters were consensual, and he denied filming anyone without consent. His attorney wrote a letter to one of the women demanding that she retract her story or face legal consequences. She decided to move forward with telling her experience. Quote, I know what happened to me and I know what I experienced, she told Insider. Quote, I know what I went through and I remember everything in those encounters so vividly. And I'm just very determined to speak up and share my story and hopefully encourage other women to feel confident to speak up. We published our stories on Dave Portnoy because we consider them to be in the public interest and newsworthy, which is again going to the defamation directly because and going to the invasion of privacy. That these are reporting on something that is in the public interest and newsworthy. And I think because of the level of, I don't know, celebrity awareness, because of the persona that is Dave Portnoy, that he is in the public forum and things regarding him are newsworthy and in the public interest. They say when a rich and famous and powerful person uses their power in that way, in a way that is harmful to other people, it is newsworthy. When such a person faces such accusations from credible sources and denies them, and then more accusers make new credible accusations that corroborate and add detail to the alleged pattern of behavior, it is newsworthy. So they're defending the newsworthiness, which is them again defending defending why they published it, because we see in the beginning of the lawsuit they're saying this is not newsworthy, this is a invasion of privacy and this is defamatory. They say the editor's note continues saying it is wrong to take a sexual encounter that began consensual and turn it violent without first asking one's sexual partner for permission. The lawsuit alleges that this statement is further defamatory. They say 5 young women have now told Insider their experience with they experienced sex with Portnoy that began consensually but turned more violent and degrading than they would have agreed to. It is wrong to film someone during sex without asking. The article, this article and Insider's November report have credible allegations from 5 women who say that Portnoy did that. They say realizing he was recording them was humiliating and made them feel powerless and at risk during and after their encounters with him. They say knowing he may still have the videos and photos of them on his phone makes them feel fearful to this day. So do I think this is a clear case? No. Do I think this is an easy defamation lawsuit? No. Um, do I think that this lawsuit potentially uh, silences those that may have come forward after the second article to speak to Insider? Possibly. Does this have a chilling effect? It could, but people are allowed to sue for defamation when they've been defamed. So there is a lot there. I will link to the full article from the full 2 articles from Barstool, not from Barstool, from Insider and the editor's note from Insider and the lawsuit where it's been provided um if you want to read the articles for context for yourself. So, will Dave Portnoy be a newsworthy public figure? I think so. Is is he part of, public interest and newsworthy? I think so. Is his Are the text messages an unreasonable invasion of privacy in Massachusetts when he is a public figure? Undecided for me, but we're going to think on it. Defamation by implication can happen. I want to look at some more of Massachusetts law on that to talk about it and look through the articles again. If you would like more than just an overview of the lawsuit and a breakdown of, okay, this is what the article said and this is what it is, because some of the quotes that they're saying are defamatory are what the sources are saying. I experienced this. And so I experienced this, if that is accurately reported, is not going to be defamatory as to Insider because they are reporting what somebody else said. Now, if that is not an accurate recitation, could that be defamatory as to the person speaking it? Yes. Did Business Insider have a duty to verify those stories? Yes. Business Insider is saying that they did. Dave Portnoy is saying that they didn't. You guys are going to let me know in the comments what you think. So, what I'm asking with that is that we talk about the legality of the thing, because again, there's a lot here, and what I don't want covering this lawsuit to do is take hate to anyone involved in this lawsuit. We're here to discuss the lawsuit and the difficulties of defamation suits. We've just seen a 3-year defamation suit end with Cardi B versus a media outlet, YouTuber, blogger. We're seeing Ryan Kavanaugh sue Ethan Klein for what was said on YouTube and on their podcast as a media outlet. And we now have somebody else who's in the media suing a media outlet. And we are going to continue talking about that. So, with that, we will get to questions real quick. So we will get to questions real quick. I know it's been almost 3 hours. We're going to do 10 minutes of questions. Then I'm going to scoot. So I have questions. You have questions. We have questions. I'm going to timestamp this. I know that was long. It's a long lawsuit, and there's a lot to be said when we're evaluating both sides of the lawsuit, because again, this is not a criminal case. This is a civil case with regard to the defamation. Could the women be sued? Maybe. If he feels it's defamatory, but also what is the goal of the litigation? Is the goal, if they're alleging Barstool Sports has lost $12 million in advertisers and the reputational harm that's been done, who is the best to take care of that or make that whole? Probably the publication and not the women. So I can understand why suing them. Also, is this lawsuit used to get Dave Portnoy's side of the story out there more? Yes, they said that was one of the goals of litigation, is to hold insider accountable and to tell their side of the story. I think Dave Portnoy's already done that in other outlets too. If you want to go seek that out, I know he's made videos about the subject. So the legal side of this, because we really got into a little bit of the law in Massachusetts and a lot of the allegations here, we can get into the legal of it more heavily on another day. And you guys, again, can read the articles and read the lawsuit and see what you think. And see, do you think that the implications are left there? Do you think that insiders just reporting what they were told and that people are saying, it felt like this to me, it felt like that to me? I mean, it's again, if this goes to a jury, down the road, y'all, and it's a request for a jury trial, y'all are the best to look at that. Oh, what I didn't say is what they're asking for. Emily, you didn't do the prayer for relief. You're right. I didn't do the prayer for relief. I'll do it real quick. And I will go through and ask questions and try to get to the super chats that I missed. You all law nerds. All right. Prayer for relief. Prayer for relief. Emily, you left it out. Yes, I did. My bad. My bad. Why didn't we get to the prayer for relief? Because I got distracted in going to the editor's note because it was contemporaneous with the second thing being filed. So, all right, let's go down to prayer for relief. Let's see. Massachusetts guarantees Portnoy the right to be free from unreasonable, substantial, or serious interference with his privacy. His rights to privacy include a right to be let alone and a right to be free from public disclosure of private facts and information without his consent. Defendants releasing and publishing of Portnoy's highly personal text messages and social media messages amount to an unreasonable, substantial, and serious interference with an invasion of Portnoy's privacy. I'm really interested in the case law about this. As a result of defendant's invasion of privacy, Portnoy was humiliated. Oh, that's not the full prayer for relief. Where's the rest of it? Here we go. That was the end of count 2 of claim 2, the invasion of privacy. Here's the prayer for relief. Judgment on count 1 and 2 in favor and damages assessed by the court, and further relief as the court seems proper. So that's the prayer for relief. The privacy one will be interesting. I really do want to pull some case law. Emily, you've said that 6 times. I know. I want to pull some case law and take a look at it because I'm really interested to see if there is case law with regard to like social media messages and text messages when you're dealing with something that is newsworthy and somebody who's in the public eye. I imagine that he will argue that this is his personal life is not newsworthy. That will be his side. And we've already seen an insider in that editor's note saying, but it is newsworthy, and this is why it's newsworthy. So that is where we're at. We'll see what Insider does next. I imagine Insider's response will be a motion to dismiss for jurisdiction and move it to New York. So I'm going to get to a few super chats, and then we're going to get to the rest of the questions. Lies. I'm going to get to this first. Howley CC says, I'm confused on if their defense is that rough sex did happen but was consented to, or if it was just all made up, because why wouldn't you mention a safe word if it was the former? I don't know why a safe word wasn't mentioned. I think that the defense from Insider will be that the lady's statements were true. And I think the allegation from Portnoy and others is that this was all consensual, and Insider knew it was consensual and alluded that it was otherwise. So by that, I mean, it's not really a defense on Portnoy's part. It's the allegations on Portnoy's part. The defense comes in Insider saying this is true and we're allowed to publish things that are true. So this is going to be a lot of perception. And that's hard with defamation. Does the article leave the perception that Portnoy committed crimes, or does the article leave perception that women regretted their encounters with him and not that he committed crimes? And so the perception and the things alluded to in the article are going to matter. And then the difference between Portnoy saying, I had consensual encounters with these women, so saying they weren't consensual is defamatory. And the women are going to say, yes, it started consensual, because that's what we're seeing from the article. It started consensual, but then it wasn't what I consented to. And that is a difficult position to be in to win a defamation suit. But which is why I said it's a little cleaner when you get to things like a police report, because you're not dealing with other people's perceptions. You're dealing with a report, and did they leave it alluded to that he was under criminal investigation or not? And if he wasn't under criminal investigation and the report clearly said that, that becomes a little easier for a jury to wrap their head around, versus a jury saying, yeah, but I don't like any of the things that happened there. And that's hard for me to reconcile the two. Super chats. Thank you so much. Katya said, good morning, Emily, and to everyone else, good morning, now afternoon, because we've streamed for like 3 hours. Sorry. Thank you, mods. Thank you, Law Nerds, for being lovely. So Eighth Wonder says, I'm working, so sneaking to ask. Sorry, this got to the end. The sage green travel mug you had, what brand is it? I need one. Keep doing what you do. It's on my Amazon store. The links are in my descriptions. This is a Stanley collab with Starbucks. Me needing to go over this way. It's a Stanley collab with Starbucks, but there are other colors. I think this color is the collab, but there are other ones that are listed on my Amazon shop. So thank you for asking. Dallas, thank you for the super sticker. Haley McInnes, I got your super chat at the beginning. Kelly B said, I met Heather at a comedy show in Chicago, and she is an absolute sweetheart. Yes, we are all thinking of Heather McDonald. Ivans, we got to that super chat. Thank you. Mama Trees said, can't tell the family yet, but I've got to tell someone. I'm going to be a first-time grandma in late October. Woohoo! Congratulations. Congratulations. And I hope everyone stays well and healthy and that it is amazing. Scott Bain said, sounds like passive-aggressive interference. Definitely outside the journalism lane. Love the purple wall lights. I love the purple wall lights too. It's very interesting. The contacting the advertisers is interesting context to it, because we haven't seen Barstool Sports as a company sue Insider, saying the things, because this gets into like the Ethan Klein case, like kind of squarely, even though it's completely different context about what was said. But you saw Triller sue Ethan Klein essentially over things that Ethan Klein said about Ryan Kavanaugh and about Triller, and then the App Store. But what you saw is the court saying you can't show damage in the App Store. I think it might be easier in this context for Barstool Sports if they have emails of advertisers saying, hey, we saw Business Insider's article. We're no longer advertising with you. It makes it a little easier for Barstool to prove that the articles caused the damage and to potentially prove interference if there are more of those emails going out to advertisers. But that's all very fact specific, and that has not been done. Dave Portnoy is suing as an individual, saying, you, Business Insider, reporters and editors have defamed me by saying these things about me. You knew that they weren't true. Dan Anderson, good to see you, Dan. Question, I'm going to drink water while I read this. Would the paywall portion factor into some of the financial remedy? Could they go after those profits as a line item if they get into discovery on this case? How much Business Insider made or how much they jumped in subscribers because of these articles, I'm sure is something they will be seeking in discovery, and it can become a consideration. But when juries sit down, and we saw this in the Tasha K case, when juries sit down to decide damages, they look at like fixed cost. In the Tasha K case, it was like medical expenses and general damages, and then punitive damages. So it will depend. But you could get into the damages portion of the trial saying, look, this is how much they made. Give us that. Give us how much they made. Oh, excuse me. Give us so much we made off this. So anyway, let's see. I'm going to get to a few more questions. Question, is there state these things occurred an affirmative consent state? Would that impact anything? So I did not look at Massachusetts, and affirmative consent means that just not saying no is not enough. You have to affirmatively, like, yes, and consent to all parts of the adult activities. But this is not a criminal case. So it doesn't, would it come up in this context? And I didn't look to see if Massachusetts was, but I can look real quick. Would it come up in this context as Business Insider saying yes, but in this state, it is a affirmative consent state, and therefore, when these women were telling us that they consented initially but no longer consented, would that factor into the defense of Business Insider saying it's true? It could, because these events all seem to have happened in Massachusetts. But this is not, and I want to be clear that it's not a criminal case, and there have been no criminal cases. Let's see. That's a great question. Thank you. Let's see. I'm not seeing that quickly, so I will need to look it up. I will need to look it up more deeply to see what their affirmative consent law states in Massachusetts, because I'm not seeing it on a quick glance. But again, those things need to be looked into. But it would come up in context of what Business Insider believed, and did Business Insider believe what they were reporting was accurate, and what went into them believing that's accurate, if that's something that they looked into when reporting this. Does that make sense? I hope that makes sense. Mooney Magoo, how far did you get before demonetization? I don't know. It's BS. So for me, I understand that the algorithm picks up on certain words. And when the algorithm picks up on certain words, it doesn't have context for if those words are in an okay setting, an educational setting, or if they're in a harassing setting, or if they're in depending on the setting. So when things go for review, they go for review. I have no idea at what point I've set it for review. So we're just, you can still see them. It's only reach that's the issue. It's hard when you talk about lawsuits, because you're talking about lawsuits and allegations, but the things are the things. So, question, can you please cover Amir Locke? Really want to hear a DA's perspective on what went down. BetBot, when I know more, yes, I can. I don't feel like I know enough yet to give any form of helpful or insightful comment. I need more information. I just don't have it yet. So when I have more info, yes, we can talk about it. Sadly, I don't know enough to give helpful comment. It would just be emotional response, and that's not helpful. So Question, I have completely run out of ice cream at my local Sonic drive-in. Is that criminal? Sandy, obviously. It's just like it's like the McDonald's ice cream maker being down. It absolutely should be a crime. I think it's a danger to public safety to run out of ice cream. I think it is a a matter of great nuisance. And I think it's abusive. So that is my teasing about, is it criminal? Obviously, running out of soft service criminal. Though I will say that Sonic does not have my favorite drive-through ice cream. I do quite like McDonald's drive-through ice cream, though theirs is always down. And Chick-fil-A has good ice cream as well. So does Steak and Shake, for sure. Ronnie A, thank you for your time and the updates. You are welcome. You are welcome. You are welcome. So let's see. I'm going to do just 2 more questions and then we're going to go. Question, when do you think we will get an update on the H3 Cav case? I need to look at the date it was filed because we're going to get up on time to answer. So we should get an answer at some point. So let's see. Rebecca, have you covered the Freedom Convoy? I have not covered the Freedom Convoy because I do not know the laws in Canada. So I don't really know much what I can add to that conversation because I evaluate the legality of things. I don't know the law in Canada. I have not seen any lawsuits filed. I don't know what there is for me to add to that conversation. And I try to add to the conversation with, is it legal? Is it not legal? Or are we discussing a lawsuit? And I can't, I have not seen any lawsuits, and I am not a Canadian legal expert. I know there are plenty of others covering it. So, Pam Marshall, I sent you a DM on Instagram about a DFW. I think DFW means Dallas Fort Worth, right? DFW influencer named Brittany Dawn is being sued by the Texas Attorney General. You might want to check it out. We talked about that at the beginning a little bit. I've gotten lots of DMs and tags about it. So Pam, I did get your DM about it. I talked about it at the very top of the stream that there's context there that I don't have yet. So it's going to take me some time to go through the context I just don't have context. So I'm curious about context before I cover it. So hopefully Friday, because Friday we're going to do Duggar stuff because the government should respond, and I will look at that too. So Bertie said there is a class action lawsuit being filed by residents in Ottawa against the Freedom Convoy. And if there is, I will definitely take a look. So it's hard because I'm not a Canadian lawyer and the laws are different. Though the laws in the states can be different state to state, it's not as different as a completely other legal system. So it becomes a little hard. Ms. Zeppelin, question, can you weigh in on Deaf Noodles proposing a class action against Keemstar? I haven't seen a class action against Keemstar. It depends on what the class action is for. So I can't weigh in because I don't know. Wendy Williams, I talked about it at the top of the show. I need to pull the legal documents before covering it, but I will be talking about Wendy Williams. Absolutely. Once I pull the legal documents, I'll be talking about it. I'm deeply curious as to what's going on there and why her bank has frozen her access and what else. I've read all the reporting, and I talked about this at the top of the stream too. I read all the reporting. There's more there. I have more questions there, and there's more I want to know. And until I pull the legal documents, I'm not going to know. I'm not going to have answers to the things I want answered. So, all right. With all of that, I appreciate all of you. Thank you for being honored. Thank you for hanging through a difficult lawsuit with a lot of topics. I think defamation suits are important to cover. I think talking about the boundaries of media is important to cover. I think that's important no matter what, because there are boundaries within media. Whether this meets those boundaries, we will continue to discuss together. And I think awareness of how damage can be done in not just reporting, but in media also bumps up against the Alec Baldwin suit. You know, how is Alec Baldwin characterizing something to 2.4 million followers on Instagram different than Business Insider doing it, different than what is going on with H3 and Kavanaugh? Like, we have so many different examples of defamation suits. I didn't realize we were going to be like a defamation covering. We were going to just cover defamation suits, but what can be said, how it can be said, and where it can be said is very important. And finding those boundaries is going to continue to be something that not just social media, but online media deals with and has to deal with. Can you repeat something somebody said, like Ethan Klein? How precisely do you have to repeat it? What if you repeat it but add implication? Same here. Can you report what somebody said? What obligation are you under to know that what they said is 100% true? When can you say, yes, I see this evidence, and yes, I've heard their story, and I've determined that this is credible based on all of this, and therefore it's being reported, and where those boundaries are? I think it matters a lot. So I will continue covering it. And hopefully the Barstool Sports contingent that goes after people will just understand that we're reporting the case here, and we just want to cover the law and see where the boundaries are. And that's what I like doing best on this channel. Lawsuits and conversations about them. So thank you for being law nerds. Thank you for being here. I'm gonna go rest my voice. We've got water in here. Cheers. Cheers, cheers, cheers. Gabriella said, in France, defamation is criminal and paparazzi can be sued. As I'm saying goodbye, I'm fascinated by this. But is that the direction that we're going into with the US? And it's interesting where freedom of speech and the First Amendment and freedom of the press bump up against where our words illegal in the you can be civilly sued for monetary damages, and where are words illegal in the criminal sense. And in most states, words are only illegal in specific types of threats of harm and things like that. So where words are illegal is definitely not criminal in the defamation sense, but where are we in that? And Ashley brought up a good point that I just wanted to touch on, also missing the malice requirement. And so I think from reading this, and Ashley, let me know if you look over it and let me know what you think, that they are trying to prove malice through the way that it was promoted and the way that it was shared on Twitter and the way that it was promoted through being used to generate new subscribers and stuff. That's what I saw them tying in as the malice element, and saying that they had this reckless disregard for the truth because they had all these messages. So I don't think the complaint's deficient on its face, like we're missing an element. I think it's a difficult case. I think that jurisdiction is going to be the first hurdle, and I will be very, very interested to see where this goes and what happens next. And we will keep covering it. So cheers, law nerds. Thank you for being here. Good to see you. I'll see you again on Friday. There will be a new, albeit late, episode of the Emily Show podcast this week. I will be on Up and Adam tomorrow. I will share that out with everybody and share it in the text crew. If you're not in the text crew, textemily.com. You know where to follow me on social. I never said do the likey, subscribey things. And now we're at the end of the stream. So if you got here, you get a gold star. Thank you. And don't forget to do the likey, subscribey things. I will see you guys in the next one. Thank you for being here.